I think you mentioned that I am respondent in a REIT appeal millets. There was a direction from the single government to pay the provisional pension millet. But that has been stayed here. Millet. I'm not paying. 2020 millet after retirement, I'm suffering millet. So last millet, take it as a first case or some this or something.
Please give it, right?
Queen of India, exhibition case is pending on 11th manner. On page
Yes.
During the lawsuit section about the matter, they have now proceed with the advertisement and filling up the post where we are working. I have filed a small IM. I just that leaving our post they may fill up. All my lord, DPQ, Departmental Promotion Quota. We are all succeeded in that, and we have been selected. Still, then they are by advertising a fresh advertisement and filling up the post, leaving us without giving us a chance. So small I have given.
Your lordships, we are the petitioners in a writ petition, and the petitioner had challenged the decision of the board of directors, the appellate authority of NALCO. The lordships, this matter has now been pending for quite long time, 2006 matter.
Lordship, I seek a short mention for accused as convicted for under section 302 IPCC. He has already served 10 years.
Well, an IA for interim bail, your lordship, his father is not.
Your lordships, we had obtained a favorable order for reinstatement from OAT Bhubaneswar, and the state has now come in challenging the order, your lordship.
I'm making another mention, your lordship, the co-appellant has already been released on bail by this order. He is an appeal.
Weekly daily first up, item number 1.
For the appellant in this case. I'm appealing for the appellant in this case. The previous occasion also was directed to us to file certain documents and a fresh date of charge.
So let's look at the last orders. It is still. I have got the SLP order, of course, but we could not get the SLP. But that order shows that both it was dismissed on merit as well as. Who told you?
It is still awaited by the appellants who will file before the lawsuit.
Wait, whatever note I have taken from the you filed the first that writ petition in 2011. That is WPC number 17171 of 2011.
Yes, sir.
Please verify it. So there you challenge the termination order dated 26/2011 and quarters vacation order dated 22/6/2011.
Yes, sir.
Right?
Yes, sir.
And that writ petition was allowed by order dated 29/9/2014.
Yes, sir.
And both the orders were quashed, but they were directed to pay 60% back wages.
Yes, sir.
Right?
Yes, sir.
And permission was also granted to restart the proceeding against you.
Yes, sir.
Right? You filed first the review petition, that number is 172 of 2014, challenging that order passed in writ petition because you claim 100% back, right? That review petition was dismissed as withdrawn. When it was dismissed as withdrawn?
Your lordship, in that review, he also asked for deemed confirmation. Even those prayers were there. Those prayers were there.
So, where is that review petition copy?
Copy that annexed 15, your lordship. The order is not annexed.
Order
No, it's all right. Review petition copy is annexure
15.
And that was dismissed on 18/11/2014.
15, and that was dismissed on
18/11/2014. 11/2014.
2014. That order you have not annexed.
Not any.
Acha. Okay, then after withdrawing that review petition, you file the writ appeal. That writ appeal number is 405 of 2015. So same prayer was made as in the review petition,
Yes, sir.
and that was disposed of on 19/4/2017. What
Yes.
order was passed?
Yes, that order and that copy of the writ appeal, also the copy of the review petition was what was before this agitated before the lordship in the previous appeal. Also directed to file all those documents as because certain documents are missing.
You have filed the, I think you have filed the writ appeal memo.
Memo I filed, but
Yes,
the
sir.
order he has not.
You don't have the copy.
Just a
So
minute.
now I do not have as least because of ill health. He has not given me those documents.
So you are asking for adjournment then.
All right, no, it's all right. So you have to give that order passed in writ appeal.
Writ appeal.
Against that time.
Also the writ appeal. Writ appeal
Against
time.
that writ appeal order.
Writ appeal.
Writ appeal time.
405. Acha, just a minute. 3A. SLP number कितनी?
919 of 21.
SLP civil 919 2021. এটা ফাইলেছি writ appeal order against.
1311
Challenging writ appeal order केवल 405. 405
2014.
It is on 405 of 2014 or
14.
15?
14.
Not 15.
Not 15, 14.
Somewhere you have mentioned as 15, I mentioned it, okay. So, all right, this is 2014. And it was disposed of on when? 19/4/2017. Acha. Challenging the writ appeal 2014. It was dismissed upon
Dismissed on merit as well as delay.
Merit.
dismissed
Merit
on merit and delay. সেটা কেবে হলো?
এটা হলো 10/2/21
10/2/2020. Okay. You file that against that writ appeal order also, you file a review petition. That review petition number is 111 of 2017. And that copy I think you have filed here.
No.
That we supplied, but
Achha.
it was not
Yes, not
the
that.
record.
Not part of
So, and that was dismissed.
that was also dismissed.
On when that was dismissed?
29/11/2019.
29/11/2019. Have you annexed that order?
No.
Okay. So then you filed this present writ petition out of which this writ appeal arises.
Alright.
There you challenged, in fact, 3 office order and 1 letter.
Yes, sir.
Those office orders are annexure 13, 23 and 27, and later is annexure 70.
Basically, the dismissal order and the wages, back wages.
Whatever it may be, this
Right.
and that was disposed of on 17 to
2017.
2017.
Yes, sir.
And against that you have preferred this present writ appeal.
Writ appeal.
So the orders which you have not filed, we have asked you in the last order,
Last one. 12/11.
that is 12/11/25.
Yes, sir.
You are supposed to prepare a date chart also.
They press date chart because those are incomplete ones and certain
So what do you want now?
documents. I prefer 2 weeks adjournment. because he has not given me those
Not
documents.
got all the documents. So that he-
ଆଉ ଏ ଯୋଉ 19/4/2017 ଆଉ 29/11/2019 were subject matter of SLP সেটা ସେ ଉପରେ ଲେଖା ହେଇଛି
SLP order টা দিয়ে দেখি দেখো। Details আছে।
SL,
19/4 read appeal 19/4 out about
review.
or review করছেন দিটা করতে হবে।
वो the orders में चले
both the orders ऊपर लिखा है and they were dismissed both on ground of delay as well as on merits.
দেখুন you are Mr.
Behuria.
Nityabrata Behuria, right? Or Mr. Nityabrata Behuria, and counsel appearing for the appellant and Swami also. And senior advocate appearing for respondent number 1 to 4, no?
One.
Question. 1 to 4. It appears that the appellant first preferred WPC number 17171 of 2011. Sumitan Jaditke Yavo point out for you. Challenging his termination order dated 26/2011 and the quarter vacation order dated 22/6/2011. Right? Stop. The writ petition was allowed by order dated 29/9/2014 and both the orders were quashed. However, the petitioner was allowed 60% back wages and permission was granted to the respondent to start a proceeding afresh against the petitioner. Stop paragraph. Against the order dated 29/9/2014 passed in WPC number 1717 of 2011, the petitioner filed review petition number 172 of 2014, claiming 100% back wages. And that review petition was dismissed as withdrawn on 18/11/2014. The subparagraph. The petitioner made the same prayer as was made in the review petition in writ appeal number 405 of 2014, which was disposed of on 19/4/2017. Stop. This writ appeal was dismissed or not? And the writ appeal was dismissed. Stop. Challenging the order passed writ appeal number 405 of 2014, review petition number 111 of 2017 was filed. And by order dated 19/4/2017, it was also dismissed. Mrs. Rautha?
The review
Huh?
a review was dismissed by 29/11/2019.
No, 29/11/2019. Stop. It appears that subparagraph. The petitioner approached the Honorable Supreme Court by filing SLP civil number 919 of 2021, challenging The order dated 19/4/2017 passed in writ appeal number 405 of 2014. So also order dated 29/11/2019 passed in review petition number 111 of 2017. And the by order dated 10/2/2021, the special leave petitions were dismissed on the ground of delay as well as on merits. Mrs. Rothel and senior advocate filed the order passed in the aforesaid SLP, which is taken on report. Stop. Far. The petitioner filed WPC number 320250 2325 of 2014, challenging the office orders dated 16/10/2014, 15/11/2014, and 22/11/2014 under Annexure 13, Annexure 23, and Annexure 27 respectively. So also the later dated 15/11/2014 under Annexure 17. This writ petition was dismissed by order dated 17/2/2017, which has been challenged in the present writ appeal number 66 of 2017. Stop. When the matter was taken up on 12/11/2025, we asked the Learned Council for the appellant to prepare and file a fresh date chart indicating all the details and collect all information from the appellant regarding filing of different cases before this court as well as before the Honorable Supreme Court. Stop. Mr. Beurial Learned Council for the appellant seeks 2 weeks time to prepare the fresh date chart and file all the required documents. Put up this matter. କେବେ ରଖିବା କୁହନ୍ତୁ ଜାନୁଆରୀରେ?
January.
Second week.
12th he's saying Monday. 12th.
डेट चार्ट पूरा सीरियली करी डेट वाइज करी दे देबो हमको डेट रिट पिटिशन फाइल प्रेयर होची या ऑर्डर हला या पास हे गला एति 60% दिया हला देन कम्स रिव्यू पिटिशन एबे फाइल हला ए दे विथड्रॉ हला नेक्स्ट डेट पूरा सीरियली कर दे दे दैट वुड बी इजियर हला केबे रखियो
He's saying 12th. I'm okay with 12th.
12 जनवरी
Till January.
सेरा ये अछि तो सोमवार
सोमवार से तक.
हां अच्छा अच्छी बड़ मत 14th रे
अच्छा.
14th of January से जो
সেটা সংক্রান্তি তো
छुट्टी नहीं
মকর সংক্রান্তি রয় 14th রে.
छुट्टी है ना 14th छुट्टी है बहुत खराब देखिए ब्लैक लगता है एकदम छुट्टी है
Lakshmi, we are appearing for OP number 8 also.
अच्छा कौन दाखिल ऑपोजिट का रेस्पोंडेंट नंबर 1 to 4 बोले रखा है एंड रेस्पोंडेंट नंबर 8 है ना ये ऊपर लिख के देवो सर एक गलत मान स्पेशल पूरा
Item 2.
As per the last direction, my lord had directed me to file an affidavit. My lord, I'm filing it today, my lord. And serving
You are required to store the copy also on this Dipali Mahapatra. Where is
Madam,
the?
Madam, my learned sin is not appearing. I'll serve it by the course of the day.
Madam is appearing for opposite party number 3 to 32. Right?
Madam.
So you serve a copy during course of the day.
Madam, I'll serve it in the course of.
Yeah.
I'm filing it today in the court. I'll serve them.
And counsel for the petitioner has filed the additional affidavit on behalf of the petitioner, which is taken on record. Copy of the additional affidavit has been served on the Land and Council for the state in court today. The Land and Council for opposite parties number 3 to 14, Ms. Dipali Mahapatra, is not present in court. Stop. Land Council for the petitioner submits that he will serve the copy of the additional affidavit on the Land Council for the opposite parties number 3 to 34 by tomorrow for So this matter on 15.
There are blank dates and all lit up.
What is that?
Last page. Second copy also you do.
Second copy, Madam.
We have asked you to file the status and all, except
Correct.
that you have said everything.
No, Madam, I filed the status, Madam.
This is to be listed with WPC number 30354 of 2020. Yes, next.
Item 3.
Lordship's order dated 15/9/2025.
Yes.
Taking review of your Lordship's order dated 15/9/2025. The Lordship found that order. Order dated 15/9/2025 in WPC 33893. The Lordship taking note of the prayer of the applicant before the Central Administrative Tribunal. The Lordship has quoted the prayer. Therefore, your Lordship has looked at the authority portion of the order of the tribunal, and thereafter observing that the original applicant, since in the meantime has retired, he will only be entitled to some financial benefit if the order is carried out. In that light, the Lordship has disposed of, in fact, dismissed my writ application. The Lordship would kindly turn to that order.
Speak little louder.
The Lordship would kindly turn to that order.
Yes.
Case 2.
Yes.
The Lordship has quoted the order of the original applicant. In fact, when that OA was filed in the year 2018 by the applicant, seeking relief that he should have been promoted with effect from 1999, and seeking parity author of applicants who were respondent 4 to 14. Those promotions were made in the year 2008. So this OA was filed in the year 2018. So after this inordinate delay, your Lordship has also taken note of my contentions regarding the delay in approaching the Learned Central Administrative Tribunal at page 4. My humble submission is that, and exactly, his representation of this original applicant was rejected by the department on the ground of delay also. That after a decade you have approached, and the Learned Tribunal has also taken note of our objection regarding delay, and no finding has been rendered on that. So that's my main ground of.
All right. Carry on that big review of it, some of the very dismissed person. Yes, ma'am.
Item 4.
Item 4, Madam. As per the direction of the Honorable Court.
Item 4 along with item 29.
Item 29 also same, man.
29 and 4.
Directed to any vacant post or not? There is no vacant.
Can you see the order date 19/11/2025?
On his legs, my lord. And techno along with 29 item which is going on in code number 20.
Once passed over.
Again.
All right, passed. Next.
Item 5. Item 5.
May I please, your lordships. My lord, in this case, the petitioner has challenged the impugned order passed by the learned Central Administrative Tribunal, your lordship. Here, the case of the petitioner, my lord, says that in the year 2014, applications were invited for recruitment, my lords, to the under the sports quota for postal assistant / sorting assistant cadre, which are clerical cadres, my lord. And here, what had happened was in the eligibility criteria, along with the sporting achievement, it was stated that the minimum educational qualifications were required.
Please come to your prayer portion in the OA.
Yes.
Page 28.
Yes. Yes.
Come, read.
My lord, in view of the facts mentioned in paragraph, the applicant plays for the following reliefs: direct the respondents to give appointment to the applicant against the post of cadre under Sundargarh division, your lordship.
So,
my lord, here what has happened is that the applications were invited. Thereafter, my lords, at page 37, at serial number 8, the petitioner was provisionally allotted the Sundargarh division.
Yeah.
Since he is a carom player. Thereafter, my lords, the petitioner at page 42 was directed by the Department of Post, by the Superintendent of Post Offices, Sundargarh, my lords, to produce the relevant documents. Now, thereafter, my lords, at page 44, the petitioner submitted all the relevant documents, and then he also made representations which are at page 47 to 48 and 49, that why there is a delay in giving the appointment. Thereafter, my lords, the petitioner made applications under the RTI Act. At page 53 in the RTI, the reply which was given by the Department of Post was that the Adib-e-Mahir qualification, my lords, which is an intermediate course, is not equivalent or is not considered valid for the purposes of employment by the central government, by the postal department, lordships.
where is that?
Yes.
Which page?
Yes. My lords, may come to page 89, my lords, which is at annexure 2, your lordship. There, my lord, it was stated that it is not recognized. On that ground, my lord, the petitioner was denied appointment under the sports quota. However, lordships, my humble contention, my lord, is
It is
that
evident just a moment.
yes.
Adib
Adibe Mahir.
certificate course offered by Jamia Urdu Aligarh is not equivalent to 10+2 standard for the purpose of employment under the central government. Circle is advised to take. So,
What can be done? Minimum qualification +2. You don't have +2 qualification. You have obtained some Adibe Mahir from Jamia, which is not equivalent to +2. The advertisement says that +2 is minimum qualification.
My lord, a clarification at page 83 was sought from by the Department of Post from Jamia Urdu Aligarh, my lords, wherein it was clarified that it is a UGC recognized course, my lord, and it has been recognized as equivalent to the certificates of the respective state boards, your lordships. And therefore, my lords, and when the communication was also given at page 42, the educational qualifications, my lord, it was stated that examination / intermediate or equivalent examination. My humble contention, my lord, is that
where is that advertisement? Let us see.
yes. My lords, the advertisement begins at page 31, your lordship.
30.
31, your lordship, which is at annexure 1, my lords. Page 31, your lordship.
No, about that educational qualification.
Yes. My lords, may come to page 42, which is a communication made to the petitioner, your lordship.
No, in the advertisement, nothing has been stated about the educational qualification.
My lord, the advertisement in terms of the eligibility criteria says minimum educational qualification, your lordship.
लिखा है 10 plus 2 pass. ये page 31 में लिखा है
Minimum educational qualification, my lord, minimum 10 plus 2 pass, minimum educational qualification. And when the communication was made under page 42, mark sheet 10 plus 2 or 12 / intermediate or equivalent examination, my lord.
page
42, your lordship. The communication which was made, my lords.
To whom this communication was made?
My lord, at page 42, this communication was made to the petitioner, my lord, by the superintendent of post Sundargarh, because the petitioner was provisionally allotted the Sundargarh division, your lordship.
Educational mark sheet of 10 plus 2 or 12th class examination, intermediate or equivalent examination. This is not there in that advertisement. It is only 10 plus 2. It is mentioned. So this equivalent, etc., that is not there as per the. It's plain and simple 10 plus 2 pass. That was the qualification. So he has written a letter to senior superintendent, but where from he got it?
Senior superintendent writes on 2015.
Oh, my lord, this is
2015.
a letter which was communicated to Sri Satish Ranjan Samant, who is the petitioner.
Not equal.
So now the government has clarified. So what can be done? That it is not equivalent to so and so.
My lord, my humble submission here is that if that, my lords, here, if lordships may allow me to place page 80, my lords, wherein
Yes.
my lords, if I may be allowed to place page 80 at annexure 2, my lords, which shows the
80,
your lordship, wherein, my lords, the Department of Posts had made a communication to the Registrar of Jamia Urdu Aligarh, wherein these examination, the details were communicated that these are the subjects which the petitioner has, my lords, cleared. Philosophy of Urdu, English, Hindi, psychology, sociology, history of India, physical and world geography, and securing first division. Thereafter, my lords, a clarification was sought. At page 81, the Jamia has clarified Jamia Urdu to the superintendent of post offices that it is correct as per our records. Now,
but that is not being accepted. Not being accepted that it is not. That
so
is
all these communication are 2015. Come to page 89.
Yes.
This 2018.
Yes.
The government of India is not accepted.
Yes.
So then,
my lord, my humble contention here is that, my lord, I would like to submit one judgment of Dev Gupta versus BC University, if lordships may allow me. My lord, a distinction there was created with regards to normal merit in sports and, my lords, merit with regards to sports persons. Now, my lords, here what has happened is that the way the learned tribunal has dealt with the case is that it has undergone the visualizing it from the perspective of a regular recruitment process. So, and all the judgments, my lords, which have been relied by the learned tribunal, these judgments, my lords, say that it is, for example, if an open recruitment is conducted, then I may not be able to claim an equivalency of qualification. But when the recruitment is primarily under the sports quota, your lordship, for someone who wants to appear under a sports quota for a clerical cadre post, and a clarification has already been sought, my lords, from the university, but despite of that, my lords, so by denial of such opportunity to a meritorious sports person, my lord,
no, you see, as my esteemed brother has pointed out, that clarification was made in 2015.
Yes.
Right. This advertisement was made when?
2014, your lordship.
Yes.
2014, my lords. 2014, my lords, the advertisement was initially made, and, my lord, it was kept pending. So, under the RTI Act, if lordships may see at page 53, the information was provided to me. If this is the RTI application which we have received, and yes, so it was kept pending, your lordship. That is why I had to seek all this information from the RTI Act. Thereafter, all these communications have been made, my lords, stating that it is not equivalent. But my respectful submission is, my
So
lords.
now what is the status that post must have been filled up by now?
My respectful submission, my lords, my instructions are that that post is remaining vacant because
What is your instruction, Mr. Whether that
Lord, we listed for first time, we don't have any instruction. Lord, come to the page 54.
54?
Yes, the last paragraph, let's see. It was issued by the Chief Postmaster, Assistant Director. He wrote to the Dak Bhavan and Delhi. Last paragraph, let's see. In view of the instruction contained in the above noted OM number dated 28/6/1978, this office is not in a position to take the decision on appointment of the above named candidate. Taking Avadi Mandir course in the recovery to +2 arts passed and seek clarification whether the course such and such offered by the Jamia University Aligarh is recognized in the +2 pass or for the employee post of postal assistant for the circular matter. Then repeatedly matter has been examined, found that he is not eligible. Accordingly, he was let. That was in counter in page 71 onwards. Page 72, it was clarified matter. Page 72 our counter before the tribunal. We specifically stated so.
Not only that, the another problem is that suppose that post must have been filled up by now.
Definitely, he cannot be
adding that man as a party. So what can be done?
And the qualification is taken by the Alien University only the purpose of Urdu language who can read his own institution like Urdu schools or anybody. It is not for the purpose of +2 or equivalent to this. It is a certificate only the purpose of this only. That was clarified.
Yeah, what do you say, Mr.?
My lord, I would like to submit once again that this particular case, my lord, my argument here is that there has to be a distinction, my lords, which has to be drawn between a regular course of recruitment.
Are you not following that? Suppose the post must, that is one aspect. Second is that post, suppose it has been filled up in the meantime, because it's a 2018 now. 2018, 7 years have passed. So what relief ultimately you will get? You have not added that man who was now in that particular post. The particular post this advertisement made, and that has been filled up since 2008.
My instructions, lordships, are that it has not yet been filled up, my lords. That is my instructions. I do not. If I had instructions that other person has been filled up, then I would have implemented that person, your lordship. But I simply went to the tribunal on the premise that on this ground of qualification, my candidature as a sports person has been rejected. But my lords, in the judgments which the learned tribunal has relied upon, here, my lords, these judgments pertain to a regular course of recruitment, my lords. Zahur Ahmed, Unni Krishnan, and Guru Nanak Dev University. Wherein, suppose I say that I want to apply for the post of a computer engineer, the advertisement prescribes that it has to be an MTech. I say I have a PG diploma in computer application, your lordship, and I claim equivalency. Then a question comes that since it is the university granting admission or the employer,
which is the authority who is competent to say whether this post is equivalent or not. They have stated that it is not an equivalent post, and they have torn down. So how can the order be passed that no, you take it as that it is equivalent to 10+2? After getting your response, they have taken a decision, taking into all these aspects, and no, it is not equivalent to 10+2. So, can the court pass the order that you accept it as a equivalent degree?
My lord.
And number two, in view of this passage of time, and you are not in a position even to say whether that post has been filled up or not, because 6-7 years have passed in the meantime.
Yes, it must be filled up. It cannot be blanket for so many long.
6-7 years, and you have not added even that man who knows that should have been added in the original application. So all those informations are also lacking.
Then
Now you
another
cannot
corresponding
say-
Lordship, page 89. Page 89 of our counter annex.
89 we have clarification.
Yes.
2018, sorry.
Yes.
What the Land Counsel for the petitioner? Mr. Pari, Land Deputy Solicitor General, and Amit Kumar Shah, Land Central Government Counsel for the Union of India.
Here Mr. Samantara is there. S. Samantara.
What is your name?
S. Samantara.
S.K. Samantara. S.K. Samantara.
S.K. Samantara, Land and Central Government
CGC,
Council.
my lord, CGC.
You are Mr.
S. Das, Your Lordship.
Mr. S. Das. Purana document.
Subhankar Das, Your Lordship.
Subhankar Das.
This writ petition has been filed by the petitioner Satish Ranjan Samantroy, challenging the order dated 1/5/2025 passed by the Land and Central Administrative Tribunal, Cuttack Bench Cuttack, in way number 545 of 2019 in dismissing the original application with a further prayer for a direction to the opposite parties to provide appointment to the petition under PA/SA cadre in accordance with advertisement number so and so under the sports quota or CORAM in the interest of justice. Stop. The original application was filed by the petitioner, wherein a prayer was made for a direction to the opposite parties to give appointment to the petitioner against the post of PA cadre under Sundargarh division. The opposite parties, the main grounds taken in the original application for claiming relief is that in the advertisement, the essential qualification has been prescribed as 10+2 pass. Sports persons who have active participation or have represented the country or the state in an international or national competition or represented their universities in the inter-university tournament conducted by inter-university sports board or represented the state school team in the national sports games conducted for schools conducted by All India School Games Federation in hockey, athletics, basketball, cricket, carom, or awarded national awards in physical efficiency under the National Physical Efficiency Drive and were within the age limit of 18 to 27 years can apply for the vacancies which were 8 in number. The petitioner applied for the post and the opposite party number 1 by later dated 19/1/2020 2015 approved his recruitment for the post of PA cadre in Odisha Circle under sports quota and was allotted to Sundargarh division under CORAM discipline. A letter was received by the petitioner from Senior Superintendent of Post Office Sundargarh Division, Sundargarh, to submit some documents and certificates in original for verification in order to facilitate his selection. And accordingly, the petitioner submitted the required documents and certificates. Stop. The petitioner didn't receive any communication from the opposite parties. Stop. It is the case of the petitioner that in the advertisement, it is prescribed that the educational qualification is 10 plus 2 pass. And the petitioner had passed Adevi Mahir from Jamia Urdu Aligarh. And according to him, it is equivalent to passing the intermediate oblique 10 plus 2 examination. This, according to the petitioner, was verified and certified by the Ministry of Home Affairs, Public Home Ministry, Department of Personnel and Administration Reforms, by later dated 28 June 1978, and it has been confirmed by the Jamia Urdu Aligarh. To the Senior Superintendent of Post Office, Sundargarh Division, Sundargarh. The petitioner sought for information regarding the status of his document verification and regarding the equivalence of Adebi Mahir with 10 plus 2 through RTI, from where he came to know that the opposite party number 1 has taken a decision that Adevi Mahir certificate course offered by Jamia Urdu Aligarh is not equivalent to 10 plus 2 standard for the purpose of employment under central government. It is the case of the petitioner that since the minimum qualification, educational qualification required for the post was 10 plus 2 or any equivalent examination which is awarded by any public university, and the petitioner has passed Adevi Mahir offered by Jamia Urdu Aligarh, and it is equivalent to intermediate standard, the Senior Superintendent of Post Office Sundargarh, Division Sundargarh, as illegally and arbitrarily not accepted the same. Stop. On being noticed, the opposite parties filed their counter affidavit. Wherein it is specifically stated that Adebi Mahir certificate course issued by Jamia Urdu Aligarh is not equivalent to 10+2 standard for the purpose of employment under the central government, as such course is recognized for the purpose of employment to the post which require knowledge of Urdu of intermediate standard. And therefore the petitioner is not eligible for appointment, as replied by the Postal Directorate. So, the London Tribunal, after going through the averments taken in the original application, the counter affidavit, and hearing the London Counsel for both the parties, took into account the ratio laid down by the Honorable Supreme Court in the case of Unni Krishnan CV versus Union of India 2023 SCC Online SC 343, Guru Nanak Dev University versus Sanjay Kumar Katwal 2009 1 Supreme Court cases 210, and Jahur Ahmad Radar versus Imitaz Ahmad reported in 2019 to Supreme Court cases 404, wherein it has been held that equivalence is a technical academic matter and it cannot be implied or assumed, and that judicial review can neither expand the ambit of prescribed qualification nor decide the equivalence of the prescribed qualification with any other given qualification, and that the tribunal lacks any competence, authority, and jurisdiction to decide the equivalency of the certificate of Adebi Mahir from the Jamia Urdu Aligarh produced by the petitioner to that of 10+2 pass. The London Tribunal, in the concluding paragraphs, held as follows, quote paragraph number 6. The Land Council for the petitioner submitted that when where is that clarification which has been made, which page?
My lord, page 42, your lordship. The communication which was made.
42.
Yes.
That the opposite party number 3, by later dated 23/1/2015 addressed to the petitioner intimated him that he has been approved for recruitment for postal assistant cadre in Odisha Circle under sports quota and allotted to Sundargarh division. And such selection is subject to satisfactory result of the verification of the following certificate and documents, in which it is mentioned that mark sheet of 10+2 or 12th of class examination oblique intermediate or equivalent examination issued by University oblique Council of Higher Secondary Education. Then you place that Adebi Mahir equivalent to the that annexure 6 or what?
My lord, page annexure 2, my lords, page 80,
84,
your lordship.
84.
84.
'83, the university has clarified to the superintendent of post offices.
83, right. The Learning Council further drew the attention of this court to the clarification that was made by the registrar of Jamia Urdu Aligarh in its letter dated 16/11/2015 addressed to the opposite party number 3, which states that several government bodies, boards, universities and institutions have recognized Adib bracket as 10th standard bracket ends and Adebi Mahir as 12th standard and consider them equivalent to the certificates of their respective state boards. Then where is that letter which they say that it is not equivalent?
89.
89.
89.
However, the letter dated 17/12/2018 issued by the Assistant Director General bracket SPN, Government of Odisha, Ministry of Communication, Department of Post, addressed to the Chief Postmaster General, Odisha Circle, Bhubaneswar, wherein it is clearly stated that Adebi Mahir course offered by Jamia Urdu Aligarh is not equivalent to 10+2 standard for the purpose of employment under the central government.
Of India.
Therefore, the Government of India has taken a decision that the certificate, the qualification which the petitioner has got by passing the Adebi Mahir certificate course is not equivalent to 10+2, and there is no dispute that as per the advertisement, the minimum educational qualification is 10+2 pass. The London Council for the petitioner drew the attention of this court to the case of Devgupta versus Peace University and Technology and others reported in 2023 bracketed 20 Supreme Court cases 166, wherein in it has been held as follows: paragraph 19 and 20. To quote this paragraph.
In that case,
The eligibility criteria indicated that the candidate must have secured at least 75% aggregate marks in class 12 bracket or equivalent board examination. The aggregate marks for SC, ST and PWD candidates should be at least 65%
in sports quota.
in sports quota. Therefore, the aforesaid observation has been made by the Honorable Supreme Court that the objective of introducing the sports quota was to promote and encourage those who excelled and gained certain degree of prescribed proficiency and achievement in defined competitive sports. No doubt, the state acts within its rights to prescribe certain minimum eligibility standard or set of criteria as the threshold requirement for admission to any particular course, given its peculiar requirements. However, taking into account the objective of introducing sports quota, it was held that the state or the educational institution can insist upon minimum educational eligibility condition. And that is not to say that such condition would necessarily and mandatorily have to be what is applicable to general candidates. The case in hand is completely different in as much as the central government has already taken a decision
lacking minimum qualification, not excellence in the academy.
in the course is number 80 gets for
89.
In the later dated 17/12/2018, that Adevi Mahir certificate course offered by the Jamia Urdu Aligarh is not equivalent to 10+2 standard for the purpose of employment under the central government. And this later has not been challenged either before the central administrative tribunal or before any court. Therefore, after going through the impugned order passed by the Lennon Tribunal, and since as rightly has been held that the judicial review can neither expand the ambit of the prescribed qualification nor decide the equivalence of the prescribed qualification with any other given qualification, we are of the view that there is no infirmity or illegality in the impugned order. Moreover, in the meantime, 8 years have already passed, and the London Counsel for the petitioner is not in a position to say that whether that particular post has been filled up in the meantime. In such circumstances, we find no merits in the writ petition. Accordingly, it stands dismissed. Yes, next.
Item 6.
Make legal. Here, the sole question to be decided by this honorable court is whether an administrative authority or a quasi-judicial authority on mere suspicion reject an application. Well, as the petitioner.
Have you received the copy of the writ petition, Mr. Parhi?
Twice I have given that.
Yes.
Twice.
Yes.
What is your prayer here?
Dear my lords, my renewal application to be granted, to be renewed by the Ministry of Home Affairs in the Foreign Affairs Division, that is the Joint Director, who has refused under Annexure 1 and 2. Annexure 1 is an order which gives no reason. My lords, under the Foreign Contribution Regulation Act, which was there in.
So was the act.
Yes, ma'am.
You sought for renewal of your application.
Application, ma'am.
What is that application for?
My lords, will see. I have been granted the society before your lordship is a charitable society and receives foreign contribution. Lordship will see Annexure 5 at page 39, my lords. At page 39, my lords, I have been given the certificate from 91 onwards, and this act was repealed in 2010 and a new act with the same provisions was enacted. But modifications were made. Section 12(6) that a person who
Can you give the text?
Please give us the act. What is that?
To the special act we cannot have.
foreign contribution, Lordship may kindly see.
Section
Foreign Contribution Regulation Act.
Lordship may kindly see the definition. What is foreign contribution?
Wait, please though.
Section 2H.
Mr. Roy, please wait.
Yes.
Section 5. Document.
Not readily available. We have got one copy.
I'll give my copy.
It's all right. We'll
You read it.
We'll say it.
Which section you said?
12.4.
Section 12. Section 12 speaks.
That is grant of certificate of recognition, registration.
Registration.
Yes.
Unless this is my application is registered, I'm not receive any foreign contribution. That is clear, my lord. Then, my lord, there's a of certificate.
Yes. 16.
Subsection 3 of section 16. The central government shall renew the certificate Ordinarily, within 90 days from the date of application for renewal of certificate to such terms and conditions as it may deem fit and grant of certificate of renewal for a period of 5 years. Provided that in the case the central government does not renew the certificate within the said period of 90 days, it shall communicate the reasons therefore to the appellant.
So this certificate for renewal has to be made within 6 months before the expiry of
the
period.
And my lords, lordship will see the certificate, the last certificate was given on Annexure 8.
Annexure 8
8
is the
page
last
44.
Just a minute.
2016. 5/8/2016. My certificate was renewed and
it was supposed to continue till
21 minutes. 21, sir.
5 years.
Yes.
Clause 8.
Yes.
5 years. Then as per this particular
I submitted my application.
provision, when you submitted?
My lords, that is in the 21 I have submitted Annexure 9, my lords.
Annexure 9 is your application.
Page is 46, my lords.
No, we just want to see the date, particular date.
Yes.
When you submitted.
22nd April 2021. Application, lordship, I'll just place it, page 46. Form
So
number
within
3C.
6 months before the expiry of the period of the certificate. So that you have submitted?
Yes.
Because you are
dispute about that.
that.
So far as this procedure is concerned, I have complied with the procedure and I have submitted. Now, my lords, what they did under Annexure 1, lordship will kindly see. Just one mail came in 23, Annexure 1 at page 17, my lords, that your renewal application has been rejected.
Under section 16(1). 16(1) says, apart from that, it is to be made within 6 months. It further says that the central government may, before renewing the certificate, make such inquiry as it deems fit to satisfy itself that such person has fulfilled all conditions specified in subsection 4 of section 12.
Yes.
But now the authority says that they apply for fresh instead of renewing.
No.
Kindly see page 20.
Lordship will kindly see. I preferred a revision application.
So in the revision it is said you apply for
an application. I'll show that, my lord, the revision order. Lordship will be pleased to see that order. Lordship will be pleased to see that order.
Against this
under section 32, I have to prefer a revision application.
32, just a minute. 32. 32 is revision power.
I prefer the revision application, and Annexure 2 is the outcome of that revision application. Now, my lord,
and they have stated what they have stated.
Yes, my lord. Page 20. Relevant page is page 20.
Let's start from page 18 onwards. Otherwise, I will be repeating.
18.
It is 18 order. The second paragraph onwards. Let's see.
What on the second?
May I read well?
Yes.
And whereas the section 16 of the Act, and Rule 12 of the Foreign Contribution Regulation Rule to FCRA 2011 provided criteria for renewal of the registration certificate. Section 16 of the Act inter alia requires that the central government may make an inquiry to the satisfactory itself that the association seeking renewal of the certificate has fulfilled all conditions specified in Section 12 Surplus 4 of the Act. Such inquiry is carried out through Central Security Agency. In the instant case, it is very important. In the instant case, it has been reported that the acceptance of the foreign contribution by the NGO is likely to be violated the provisions contained
Likely
under the
to be violated.
12.2. Let me complete.
Yes,
12.4 of the FCRA 2010
sorry for the
as the
interruption.
organization is
Madam.
aggressively pursuing its agenda for inclusion of Sarana as a separate religion in Indian constitution, which may lead to be law and order incident in further. The acceptance of the SC under the FCRA 2010 is likely to be created faction among the non-Christian tribals, as the organization has been mobilizing the tribals for a movement of support of their demand for the conclusion of Sarana as a separate religion in Indian Christian. They are contributing the foreign contribution for converting the Christians from Hindus. And let's see the part of the order provisions I have read. Section 16, subclause section 16, subclause 3, then provide what he had not read. They provided further that the central government may refuse to renew the certificate in case where a person has voluntarily violently and the provisions of this act or the rules made thereunder. So in this context, the government of India certified that the particular NGO has violated their money for illegal purposes, illegally, for which their revision is not being taken into consideration.
So, Mr. Roy, this renewal is not a right. Renewal requires.
It's a right.
So renewal requires some inquiry. They have already carried out the inquiry.
Yes. Manners now.
Come to a finding.
The thing is that, Manners,
yes.
Lordship will kindly hear me. This inquiry report has never been confronted, has never been brought notice.
No, it's a secret matter. It's a question of country's security and.
And option is given to you to apply for a press.
1 minute,
It's not a general matter that it should go given to you. And
this Hon'Ble Court, in the similar case, identical case of another NGO in 2023, he delivered a judgment and said that direction giving that also given the report of a central agency saying that we are converting the Hindus into Christians. Then, my lords, will see para 11 of the judgment of this division bench.
Yes.
Of the judgment para 11, lords will kindly see. There is a question, my lords. First thing is that, my lords.
Which paragraph is?
Para 11, my lords. We have meticulously.
Wait.
Yes, my lords.
बाहर कर उसे तो ये समझ देवे ना नहीं.
Again.
Yes, paragraph 11. Yes.
We have meticulously appreciated the field inquiry. It is what I say, sir, special agency, and the purported evidence of the opposite party. We are persuaded to hold on such scrutiny that no reason supported by reliable evidence has been provided to this court to justify the action taken by the opposite party by refusing the renewal of the Foreign Contribution Regulation Act certificate by the Annexure 1. And as consequence of our opinion, we strike down the decision of the opposite party for not renewing FCRA certificate. We direct the petitioner to reconstitute the society, and they have later on they have given the allowed the renewal certificate. And no, so manners, two things here, manners. One is that I am not asking, my lords, the report to be submitted to me. All that I want, my lords, let this Hon'Ble Court peruse that report. What is there?
No, or it is the satisfaction of the authority.
My lords, that satisfaction, my lords, has to be an objective one.
Objective means inquiry finding.
See the case which you are citing. What was they running? They were running.
They were in
So no, kindly see para 3.
Yes.
They were running a special school for mentally challenged persons and for giving them training towards the holistic development and early intervention and behavior modification, psychology and physical and vocational training. And what kind of educational institution you are running? These two are completely different institutions. Therefore, the inquiry report may be different. That inquiry report can't be equated with the inquiry report of
inquiry report may be different, but the allegation was the same. Here I am
for
changing.
educational institution, you need foreign.
All right, the writ petition has been filed by Utkal Jyoti Educational Society challenging the order
Lecture 1 and 2.
order dated
One is the order and second is the consequence of the revisional order.
20th January 2020. And 21st, এটা 21 May না
21 February.
21st May, no, second next
second
21st May 2025 passed by the Joint Director FCRA, Government of India, Ministry of Home Affairs, Foreigners Division,
Opposite party number.
the opposite party number 1. The opposite party. The factual scenario as it appears that the petitioner society of the association was granted registration certificate
3.1 activities
on 10th November 1990 under Registration Act,
Foreign Contribution Regulation Act. Annex 5.
and accordingly it was registered under FCRA Act, and it is stated that the association is engaged in administering the educational and training institutions and related establishments, and to conduct training courses, seminars, lectures, discussions for students, teachers, social workers, technicians, and other personnel for the staffs of colleges, high schools, middle school in the matter of theoretical and scientific pertaining to diffusion of such knowledge, mass communication, and related subjects for all classes of people without distinction of caste or creed, and to give award scholarships, diplomas, and certificates in respect thereof. It is stated that the petitioner was receiving the renewal of registration under FCRA time to time granted by the Ministry of Home Affairs, foreigners, and by order dated 5/8/2016 of the Director, FCRA, Foreign Division, the renewal of registration was made, and it was for a period of 5 years. When the petitioner society submitted an application for renewal of the certificate in the prescribed format on 22/4/2021. The opposite party refused to renew the certificate, holding that the petitioner society is likely to violate the provisions of FCRA Act, which means, according to the petitioner, that the rejection order was made on purely conjecture and surmises. It is the case of the petitioner that the allegation of the Central Security Agency was never confronted to the petitioner society to raise its objection, which is violation of principle of natural justice. Against the refusal order for renewal of the application dated 20th January 2023, the petitioner filed the revision under section 32 of the FCRA Act, and the revisional authority also rejected his application, which according to the petitioner was illegal and arbitrary.
Directed to apply for a fresh.
Stop. The Mr. Roy, a land senior advocate appearing for the petitioner, placed provisions under section 11 of the Foreign Contribution Regulation Act and section 12. So also section 16, which deals with renewal of the certificate. According to Mr. Roy, section 16 of the Act prescribes that every person who has been granted a certificate under section 12 can have such certificate renewed within 6 months before the expiry of the period of the certificate. In the case in hand, since the certificate was issued in favor of the renewal was last granted on 5/8/2016 for a period of 5 years, the petitioner applied for renewal on 22/4/2021. That was in consonance with section 16(1) of the said act. The Land Council further submits that though the proviso to section subsection 1 of section 16 states that the central government, before renewing the certificate, can make such inquiry as it deems fit to satisfy itself that such a person has fulfilled all the conditions specified in subsection 4 of section 12. But in the case in hand, when the inquiry report has been submitted and it has gone against the petitioner, a copy of such inquiry report should have been given to the petitioner to have his say on the matter. And without giving opportunity to the petitioner and without giving a copy of such inquiry report to the petitioner, the impugned order passed by the authority in refusing to renew the application is illegal and liable to be quashed. On a perusal of the impugned order under Annexure 2, where detailed reason has been given, we find that in the instant case, the inquiry report has come that the acceptance of foreign contribution by the petitioner NGO is likely to violate the provisions contained under subsection 12.4 of FCRA, 2010, as the organization is aggressively pursuing its agenda of inclusion of Sarana as a separate religion in Indian Constitution, which may lead to law and order incident in future. The acceptance of FC under FCRA 2010 is likely to create faction among the non-Christian tribals, as the organization has been mobilizing the tribals for a movement in support of their demand for inclusion of Sarana as a separate religion in Indian Constitution, as a result of which law and order incident cannot be ruled out in future. Therefore, it has been held that in view of the provision under section 12 of the said act, that the person is not likely to use the foreign contribution for personal gain or divert it for undesirable purposes or to affect public interest and harmony between religious, racial, social, linguistic, regional groups, castes, or communities. Accordingly, the competent authority decided to deny the renewal application of the petitioner association. However, it has been held that the petitioner association may apply for fresh registration on fulfilling the eligibility criteria as per the extant act and rules. Mr. Royal and senior advocate placed reliance in a division bench decision of this court in the case of Messrs. Asa Kiran Charitable Society versus Secretary to the Government of India, Ministry of Home Affairs, dated 12/9/2023, wherein
Para 11, ma'am.
This court has been pleased to held as follows. Quote paragraph number 11. Stop. In the said case, the petitioner was engaged in charitable activities and they were running a special school for mentally challenged persons for giving them training towards holistic development by early intervention, behavior modification, psychological, physical, and vocational training, and for bringing them off as dignified human beings. However, in the case in hand, the when the report has come that the NGO is likely to violate the provisions contained under subsection 12.4 of the FCRA 2010, and the organization is aggressively pursuing its agenda of inclusion of Sarana as separate religion in the Indian Constitution, and the same may lead to law and order incident in future, and it likely to create faction among the non-Christian tribals, as organization has been mobilizing the tribals for movement in support of their demand for inclusion of Sarana as a separate religion in the Indian Constitution. We are of the view that the inquiry report which has been submitted in the said case, as pointed out by the learned counsel for the petitioner, and in the case in hand, is totally different. There is no dearth of power with the authority concerned not to renew the certificate. In fact, the London Deputy Solicitor General has rightly brought to the notice of this court the second proviso to subsection 3 of section 16, which says that the central government may refuse to renew the certificate in case where a person has violated any of the provisions of this act or rules made thereunder. Therefore, in view of what has been found in the inquiry report, we are of the view that the authority has passed the order, impugned order rightly, and there cannot be said to be any illegality in this same. Moreover, the petitioner has been given to apply a phrase for registration, and needless to say that even if this renewal application has been rejected, if he applies phrase registration and the authorities are satisfied that he meets the association meets all the eligibility criteria as per the extant act and rules, they can consider the case of the petitioner without being prejudiced by the earlier rejection of the revision application. Accordingly, we find no merit in the writ petition, stands dismissed.
Item 7.
Item 7. For OP number 3, Mr. Partha Naik is appearing.
Yes.
Mr. Partha Naik is appearing for OP number 3.
Okay.
And his father has passed away day before yesterday.
So I beg to appear for OP number 1.
He's the retainer counsel for IAMC man. OP3.
So, Mr. What can be done?
Because the press admission matter, but
No, we can. When he's supposed to return?
Any date after 20, man. Any date after 20.
20 means 22nd valid.
22nd
valid.
All right. Mr. and senior advocate is present. That is the one of Mr. Deputy Solicitor General, Mr. Pari is present for opposite party number 1. A mention is made on behalf of Mr. Partha Naik, the land counsel for the opposite party number 3, that since there is bereavement in the family, the matter may be taken up on some other day. Mr. Mishra and senior advocate has no objection to such prayer. Is this matter on 22nd December 2025.
Lordship, I am appearing for OP number 1, Secretary IND. Om Prakash.
Mr. Om Prakash, land counsel, appearing for, but it is Mr. Pari ko na likhaichi for whom he is appearing.
I don't know. He is our central government council. No, what capacity appearing for secretary? I don't know. Who is he?
Mr.
I have been instructed, given wakalatnama from the ministry.
Ministry cannot give the wakalatnama. Misconception. You may be given for a BC or anybody. Secretary, Government of India can't give in wakalatnama all over India. I have not seen that system. Maybe conceived. All right.
Let me get this.
Yes.
By name, the parties are included.
By name, that is not maintainable. How they are engaging all these things. Might have this secretary don't know.
Why, Mr. Mishra? Why have you implemented this?
These are all out of content matter. These are arranged out of content matter. That is the reason why they are.
No, this is not a content matter.
No, the cat matter was the content matter. I filed content application. Content application has been dismissed. Challenging that, I filed the data application.
So the problem is that suppose this person who are the secretary will be taken in.
Then I'll have to plead another the present incumbent also. Present incumbent also.
Mr. Saran says that suppose he is will file the wakalatnama for that Sanjay Jaju, let us say, and tomorrow somebody else would come.
Then the press, the new incumbent has to be pleaded as party. So that is the requirement, my lord. I cannot help it.
Annex 22, the impugn order, you have implemented by name.
If it is against contempt, then it is not maintainable. So you will go to the Supreme Court.
Yes, it is maintainable because Supreme Court judgment I have got. I have got the Supreme Court judgment. It is only representation maintainable. Not seeing that judgment, I have filed it.
In High Court as well as the CAT.
Yes, Mr. Pari, I have got that judgment. If you say, I can also right now I can hand it over. By seeing that judgment, because I was of the opinion that after seeing that judgment, I filed it application.
Section 19. Section 19.
Section 19, but Section 19 the appeal lies. But Supreme Court also that dropping Section 19 will not be. But Lordship kindly see the judgment, my lord. So Lordship kindly see the judgment. Lordship kindly see the judgment.
No, first let us see that.
Subject to the other provisions.
Content of Court Act Section 19. Appeal lies to Supreme Court.
17 first what happens?
But the Rel Chandra is, it's all right.
It's not like
But there is a specific provision for us, content of Section 19.
When they are not found guilty of contempt, to only remedy to notice that is the Honorable Supreme Court and Brajendra Singh Chauhan has decided.
An appeal to life, the right so and so.
I'm holding him guilty.
Decision.
If they're held guilty, then only appeal will lie.
It is administrative tribunal.
Supreme Court in Midnapur People's Cooperative Bank case had already held that, and that has been reiterated in Brajendra Singh Chauhan case.
Say the same relation, power and authority with respect to the contempt of itself as the High Court.
Here, what has been in that content petition?
Content application, our content application was filed, and content application they are not guilty. They are not. They're not guilty. And your Lordship, kindly see the judgment ballot. Only one page order. Yes. We find that in view of the judgment of this court in Midnapur People's Cooperative Bank Limited and others versus Chunilal Nanda and others reported in 2006 volume 5 SCC 99. In order of holding that respondent are not guilty of the content was not an appellable order. In view of the law laid down by this court, the only remedy that too in exceptional cases to a person agreed by the order of tribunal was to challenge the same by a petition order appeal to the question. That is, after seeing this only I filed it application. Otherwise I would not have filed it application.
Direct. Not found guilty.
And representing the Chandra Kumar case.
Acha. This writ petition has been filed by the petitioners challenging the order dated 26/9/2025 passed by the National Administrative Tribunal Circuit Bench Pattern in CP number 260/0069/2020. In dismissing the CP, stop. It appears that the said CP was filed for non-compliance of the order dated 13/7/2023 passed by the London Central Administrative Tribunal in OA number 163 of 2018, in which the opposite parties were directed to regularize the services of the petitioners from the initial date of joining with all consequential benefits, and the entire exercise to be completed within a period of 90 days from the date of receipt of the copy of the order. A preliminary objection was raised by Mr. Parhi, Land Counsel, Deputy Solicitor General, that the writ petition is not maintainable against the order passed by the Land Central Administrative Tribunal in dropping the content proceeding. Our Mr. Mishra and Senior Advocate, till the attention of this court to the order dated 2nd December 2024, passed by the Honorable Supreme Court in the case of Brajendra Singh Chauhan and others versus Giridhar, Armane and another, wherein it is held as follows. Quote paragraph number 1 and 2. In view of such decision, there is no dispute that the writ petition is maintainable. Stop.
My humble submission, my lord, that
Fine order. Fine order.
If Lordship refer to the section 17 of the Criminal Act, it is better.
Orders or judgments are signed.
Since they're taking adjournment, let them file counter. Your Lordship can hear both sides and pass. Your Lordship will dispose of the case so that it not very simple matter. Which is not that. Let them file counter. Otherwise, I will again another waste of time.
The thing is that the Guardian
With regard to
Council,
maintenance
he has
parties,
not
clear
filed
of
the
course.
Nama, states that he has instruction to appear for this Sanjay Jaju and secretary.
Yes.
And of course, somebody else has to be noticed in this matter. He is opposite party number 2. So let us.
Yes, sir. Oh,
yes.
much. Much.
Item 8.
Yes. Mr. Rothon, what is the matter?
Here the action purchaser is the petitioner before my lord, challenging the inaction of the opposite parties in issuing sale certificate sale letter in favor of the petitioner, even after accepting the entire bid amount.
In this matter,
Though it is late.
appropriate time has been given 90 days extension for payment of the dam. Within that period, he could not able to pay the deposit the amount. So my lord may direct without taking my concession with interest and other charges, we may accept it. With years period is fixed for 90 days.
It has already been paid.
Paid. He has paid delay up for 30 days, 30-40 days sometime.
No, you are not filing anything on the oral submission, or can you ask him to pay the interest on you?
I have got the instruction. If court direction will there, they cannot.
We don't know how many delay he may dispute it.
Then kindly supply.
An extension has been allowed for that. That is how he has paid. Otherwise, deposits have been made on several occasions.
The writ petition. Just a minute. The writ petition has been filed by the petitioner Pratap Bagh, who is the auction purchaser, with a prayer for a direction to the opposite parties to issue sale later oblique certificate in his favor, as he has deposited the full bid amount. Stop. As it appears from the averments taken in the writ petition that the petitioner, pursuant to the e-auction sale notice, offered his participation in the auction which was held on 13/11/2024, and he was declared as the successful bidder, and he deposited rupees 4,67,500 toward the EMD on 20/11/2024, and thereafter on different occasions he deposited the bid amount totaling to 46,75,000. The petitioner finally deposited rupees 3,01,250 on 28/11/2020 and approached the bank manager with request for extension of time for depositing the balance bid amount, and which was granted, and ultimately, when you paid back the entire amount?
Entire amount on 13/6. 2025.
On 13/6/2025, the petitioner deposited the balance bid amount towards the full bid amount, and it is stated that the opposite party accepted the same and transferred it to Surface Eye auction proceeds account and requested the regional manager for issuance of sale certificate in favor of the petitioner. But such certificate has not yet been issued. Mr. Coral and counsel appearing for the submits that he has instruction to appear for
filing also bakla.
I'll give it. Has filed wakalatnama for the opposite for the opposite party and submits that he has obtained instruction that the petitioner has to pay some more amount towards interest.
Interest and charges.
Interest
and charges.
And after once he deposited the same amount, there would be no difficulty in issuing the sale certificate. However, it is not clear that how much amount is to be paid by the petitioner, and Mr. Kara submits that he will file an affidavit of the concerned branch manager to that effect, serving a copy on the land council for the petitioner within by next week. Next week ମାନେ ଏଟା ପଡିବ ଆମେ লিস্ট କରିବୁ କେବେ କଣ ଆପଣ 15 ତାରିଖ ଭିତରେ ଯଦି ଦେଇ ଦିଅନ୍ତି
15 ତାରିଖ
ତାହେଲେ 17 ତାରିଖ ମ୍ୟାଟର ଆସି ପାରିବ
ଆଜ୍ଞା
17th of December 2025 by 15th copy of which shall be served on the land council for the petition. ଆପଣ ଦେଖନ୍ତୁ ତା ଦେହରେ କେତେ କଣ ସେ କହୁଛନ୍ତି କଣ ତାଙ୍କର yes as it appears you have not deposited within stipulated time.
No.
You have given extension time.
Yes, I have been given extension. I have been given extension.
So
for that reason, I could.
But there is no document where extension is given, only recommendation.
All right, next. Public.
Item 9.
Lord, this repetition is against the order of the Ombudsman and GRF refusing to entertain the complaint and also the consumer representation case. There was a verification conducted by the TPCODL staff. And
appeal provision, etc., that is been taken care of. Appeal provision,
appeal provision is there.
Yeah.
Since the authority who has inspected the premises is not the authority under 126, that is the assessing officer, and the assessment as made.
No, we just want to say that whether there is any appeal provision against the implementing order or not.
No, Miller. According to me, Miller, there
Madam,
is
what do you say?
No, let me.
Have you not received the copy? Copy did you want them?
Last time,
Miller, the copy will take up
your
and it over. Tomorrow. Day after tomorrow. Tomorrow this bench is not there. This is a different bench. You hand over.
No, I am serving copy. For the moment, I appreciate. When if the final assessment order which not be made final within 30 days from the date of service of the provisional assessment order, then it will be null and void.
We just want to say that you have exhausted all the remedies. Only that point we want to be confirmed.
Yes, there is no scope for me to prefer appeal when the final assessment order was not passed.
Day after tomorrow will
final assessment order is required to be passed.
Let's be Marana come.
Madam,
without electricity,
what will write?
Why my anxiety is I am without electricity since March 23, Miller. When by order
March 23 light night power
मत इंट्रीम ऑर्डर कले 25 लाख डिपॉजिट करो लोन करके डिपॉजिट कर देते तापर कहले कैश मेंटेनेबल
yes just give your name we used to appear for the Mr. Maran आपन सीनियर का नाम लिख दियो तो ना submits that is not having the copy of the writ petition. Accordingly, Mr. Das, Land Council, supplied him the copy of the writ petition, put up this matter on 10th of December 2025, indicating the name of the Land Council for this one. You file your power or appearance memo, whatever. Yes.
Item 10.
Lord, I mean, pardon, item 27, another matter of mine, Lord, that regarding supply of electricity, that basing on that case in Enan case, Lordship past observation in that case, can it be taken up?
Just, let us, we are going serially, please. Yes, item 10, Mr. Das.
May please, Your Lordship, Lord, the petitioner said the legal heirs of the deceased borrower, legal heirs of the deceased borrower, Lord, the bank has issued statewide e-auction sale notice without following procedure established under law. Lord, then Lord, once the borrower dies, the proceeding which was subsisting when he was alive could abate. And Lord, thereafter, Lord, second bank of mark.
E-auction sale notice challenge করছেন
Yes, my Lord.
You have to
Annexure
challenge
9.
it before some other forum.
Pardon, my Lord.
You have to challenge it before some other forum, not here.
Alternate remedy.
Oh, my Lord, I bow down.
Prior to this, my Lord,
I bow down,
they
my
have
Lord.
approached this court 3 times, my Lord.
Order against it?
Yes, no, this sale notice prior to also there is a sale notice, my Lord. It was somehow I am giving the orders, my Lord.
With due respect, submission, my Lord, I complied the direction. This honorable court directed
they have
to
to
get
then,
no tax. I deposited. This honorable court directed to pursue OTS. I filed OTS.
2011
During pendency, the borrower died.
Just a minute.
During pendency, borrower died.
my Lord.
ଏଇ ଯୋଉ ସେଲ୍ ନୋଟିସ୍ ଇସ୍ୟୁ କଲା ପରେ
ଏବେ ଏଇଟା
ଆପଣ ନାଇଁ ତା ପୂର୍ବରୁ ଯୋଉଟା
ଆଜ୍ଞା।
କରୁଛନ୍ତି ଆପଣ ତାପରେ ପ୍ରୋସିଡ୍ ତ କରୁନାହାନ୍ତି।
ନାଇଁ ତାପରେ ପ୍ରୋସିଡ୍ ମଝିରେ ଥିଲା ତିନିଥର ଆସିଥିଲେ କୋର୍ଟର ଡାଇରେକ୍ସନ ଅନୁସାରେ ପ୍ରୋସିଡ୍ କରିଥିଲେ ଓଟିଏସ୍ ପାଇଁ ପ୍ରପୋଜାଲ ଦେଲେ ଓଟିଏସ୍ ପୁଣି ଆକ୍ସେପ୍ଟ ହେଲା ଓଟିଏସ୍ ଆକ୍ସେପ୍ଟ ହେଲା ପରେ ଓଟିଏସ୍ ବି ପେମେଣ୍ଟ କଲେନି
not intimated.
yes intimate
Last
time ବି ଓଟିଏସ୍ ତାଙ୍କୁ କୁହାହେଲା ଦେବା ପାଇଁ ସେମାନେ ବି ଦେଲେନି
ମୁଁ ପଇସା ଦେଇଛି କିନ୍ତୁ
ହଉ ଆପଣ ଯାଆନ୍ତୁ ଆପଣଙ୍କ ଜାଗାକୁ ଯାଆନ୍ତୁ।
ନାଇଁ ଆଜ୍ଞା ଯଦି procedure maintained by my lord, if the procedure has not been maintained, my lord, my lord, I must not vouchsafe.
ସବୁ ଜିନିଷ ସେଇଠି କହିବେ।
My lord, I must not vouchsafe to venture this. Lord, I may not venture to vouchsafe, my lord. Procedure ବାପା ନାଁଟା ଏଇଥିପାଇଁ ବାପା ନାଁ ମୋଟ my lord, ବାପା ନାଁ ମୋଟ ସେଇଥିପାଇଁ applicable ହବନି, the default occurred before 16. Default occurred before 16.
ଆପଣ ପରା ଏବେ ଯାଇକିନି ଅର୍ଡର ନେଇକିନି
ନାଇଁ ସେ borrower ବାଲା disease default occur କରିଥିଲା 2016 ପୂର୍ବରୁ ତ ତାପରେ ମୁଁ ଟଙ୍କା ଡିପୋଜିଟ୍ କରିଛି।
appears not challenge the order dated from ସେ decision ଗୁଡା କୋର୍ଟ
ବାପା ନାଁ ମୋଟ
ରେମେଡି ବାପା ନାଁ ଯେତିକି ଅଛି
ଏଇଟା applicable ହବନି ଏଇଥିପାଇଁ କି ତାପରେ ଦୁଇରେ if they consider I'll deposit take instruction ମାନେ
କରୁନାହାନ୍ତି ଆପଣ ଆଗରୁ
ନାଇଁ ଦେଇଛି ତ ସେ ମୁଁ କହୁଛି
Item 11.
ମାନେ କପିଟା ଦେଇଥିଲି
item number 11
May please, Lord. May please, Lordship. My lord, the matter has been filed over the seeking a review of the judgment 29/4/2020. Well, in the meantime, it was filed in 2020, my lord. There is presently a condonation delay of 69 days. My lord, my submission with this regard is the matter was filed within 15 days from the date of judgment, my lord. Along with that, the copy, along with that, IA was filed number, my lord. You had no without certified copy? Yes, my lord. Without a certified copy, but a true copy of the same was annexed in the annexure 1, my lord.
So have you given a copy to the other side? Your interim application copy for condonation of delay?
My lord, an objection was also received in this regard, ma'am.
You have, Acha. Who is the counsel for?
I'm appearing on behalf of Hara Prasad Panda. I'm appearing on behalf of Hara Prasad Panda.
No, I'm telling about High Court को panel है जिब्रा जो represent करिया पाएं तो तां फोन है कि panel भी तो देवे ना he has served a copy on you that interim application and it seems that objection has already been filed but you cannot appear because the panel somebody has to authorized to argue the matter on behalf of the High Court. So just bring it to the notice of the What is your good name, Land Council?
My name is Mohammed Shaikh Ali, my lord.
Mohammed?
Shaikh Ali.
You have got no power in this case?
No, my lord.
So you are appearing on whose behalf?
Haraprasad Panda, my lord.
So and so is present. This application is for condonation of delay, and the stamp report has pointed out that there is delay of 1669 days in filing the review petition. The opposite party number 2 has filed objection to the delay condonation application. Since the panel list has been prepared in the meantime as to which to represent the Orissa High Court, and counsel for the state seeks some time to bring this matter to the notice of the Registrar General, Registrar General, for taking necessary steps. Yes, of this matter in the week commencing from 17th December, so on. So yes.
Item 12.
Look, there is a delay of about 70 days. But I will serve a copy on Mr. Rautrai, who was appearing for the opposite party, and the better may be fixed.
संजीवनी रहा पाई की appear करते अपन का writ petition में
petitioner S.K. Patnaik was appearing. S.K. Patnaik has become ill, and he has given in writing that he cannot file this.
Then on whom you will serve the copy?
No, for the opposite party, my lord, I will be serving on Nirmal Kumar Rautrai. Nirmal Ranjan Rautrai. He was
at that point of time, you were the counsel for the opposite party.
Yes, ma'am. Yes.
All right. IN number so and so. This is an application for condonation of delay, and the stamp reporter has pointed out that there is delay of 81 days in filing this review petition. The opposite party ke jona chahungi.
Jona.
Issue notice on the question of limitation. Land counsel for the petitioner submits that in the writ petition, Mr. So writ petition
Nirmal
Ranjan Rautrai was appearing for the sole opposite party, and will serve a copy of the review petition along with the IA on the land council, and the matter may be taken up next week. As prayed for, list this matter on 15th December 2025. The name of Mr. Nirmal Ranjan Rautrai shall be reflected in the cause list, and the land council for the petitioner shall serve a copy of the Agutta Jaisya. Yes, in the meantime. Yes, next.
Item 13.
May please, can you have a glance at the last order?
Last order.
My lord is already directed to take instruction about.
Yes, we have taken the instruction that when the register of the party, then the High Court panel lawyer will appear. But this is the case of the civil
panel.
Then the government will be appear.
That means you will appear.
Yes.
Okay. So, okay, then if the pleadings are complete, then you can argue the matter. This writ petition filed, counter is there, rejoinder is there.
I have to find a date chart and written note, my lord.
But somebody has filed this list of dates and note of submission is there. You want to file further?
Further, yes, my lord.
It's filed in 2018.
18. I will file in.
You want to file it afresh?
Afresh, my lord. Actually, want to maintain the total file length
The Land Council for the state has obtained instruction as per the order dated 26/11/2025 that it is the state panel uh, 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 from the AG office, State Council panel from the AG office represent the opposite parties. Number one, stop. Though it seems that the pleadings are complete and list of dates and written note of submission has been filed on behalf of the petitioner, but Mr. Guru and counsel appealing for the petitioner took some time to file a fresh date chart with additional written note of submission. Put up this matter favor of your next week, yes, next week. This week matter on 17th of December 25.
Yes. The total file regarding the selection and appointment may be called for because I have challenged.
Keep that ready with you.
On the file.
Already ready.
ये कोर्ट संगत
अच्छी पर कौन सी yes 17/12/2025 yes next please.
Item 14.
Because the last occasion directed me to take instruction from the opposite party number 2. For the last order, my lord. Now the matter has again referred to the government because the opposite party number 2 said that since the Honorable Court has directed the opposite party number 1 to submit the instruction, the opposite party number 1 has now referred to the opposite party number 2, for which the letter has been again issued.
Mishra.
No, they are now. My lord have directed London State Council to take instruction up on that particular government resolution, subsequent resolution 13/25. And the last occasion, Mr. Parthasarathi, Mr. Additional Government Advocate submitted that we have nothing to do. Now the High Court will do. That is why last occasion my learned friend has taken time. Now they are saying the Home Department will give the instruction. Now my say what to do.
This is
because my lord's order in 1411 is a clear exhaustive order, man.
We are just asking you to, you are appealing for the state. This letter has been addressed to the Additional Secretary on dated 26/11/2025. So order this letter is issued by this court. So ask your Additional Secretary to communicate give the response so that this matter can be adjudicated.
My lord's order 14/11/25. That is the exhaustive order. Again.
14/11. All right. As for the order dated 1/12/2025, Ramakrishna Bishui and counsel who is appearing for the opposite party number 2 has produced before us a communication made on dated 26/11/2025 by the special officer special cell, the additional secretary to the government of Odisha Home Department, Bhubaneswar, for taking necessary steps for compliance of the order of this court dated 14/11/2025, passed in WPC number, passed in this writ petition.
Yes, 4900.
Passed in this writ petition. Land and Council for the state seeks some time to obtain instruction regarding the response, if any, has been the decision, if any, has been taken by the government and placed for an adjournment. Please this matter. ଆମେ ଏଟାକୁ ରଖୁଛୁ 19 ତାରିଖ ଶୁକ୍ରବାର. So we just bring this matter to the notice.
For 22nd.
22nd of December 2022. You also just apprise this law secretary. He can expedite the matter, right? Put up this matter. This is taken on record for the communication made taken on record by Skype. Yes.
Item 15.
Yes, Mr. Patnaik.
The two writ petitions, my lord. In both these cases, the petitioner prayed for direction to set aside the Annex 10, my lord, of the impugned order. That is the OSF access power purportedly exercised on 29 issue notice, my lord, where admitted there is no loan survives. We all paid. What prior to that?
The pleadings are complete.
Clear,
Yes.
yes.
So tell us about your case. What is your case? What is your prayer in the writ petition?
So
have you prepared a date chart?
I have all filed.
Already filed. Let us see that.
So I draw also kind attention to Annex 1 itself. This is a very important document.
You tell us the case. What is the
Just
case?
tell us about the case.
So petitioner admittedly purchased the seized unit from the OSS miners.
Okay.
To develop his business, he availed a term loan first. Then in 1999 super cyclone damaged, he availed a cyclone loan. They are regularly paying it. In the meantime, the State Financial Corporation made an offer to settlement of the amounts, equal amount to OTS, one-time settlement to be made. The petitioner applied and his application being eligible accepted, and the petitioner has paid the upfront amount and other installment. Thereafter, the OTS was modified to another scheme, and petitioner given option to switch over, and he switch over, and he has paid the term loan. Entire clear. So only the question of cyclone loan. So cyclone level, it was allowed, and the petitioner started paying it. For some default, the recall notice was issued. The petitioner approached this honorable court, and the petitioner, this allowed the writ petition saying for the default period, I will pay interest, regular installment plus default interest money, delayed interest. So that I have paid money. So thereafter they recall the notice, so the no loan survives. How can they recall the term loan? Now can you see the two annexes I will show you minus that will make sufficient.
No, can that matter not be referred to mediation? No, we just want to know
I don't have
if any, both of you, this
move closer and Jode annexer will cleanse the issue. There's nothing survives. No loan survives. What is it?
Mediation
Yes,
जाओ थोड़े जाएंगे पेश ठीक ना
We'll try if this can be possible. Why not?
Yes, question of payment and if it can be
for payment for delayed period. That's all.
That is why.
But in the meantime, the recall that has been recalled since he did not obey the order of the High Court.
But once he clears, because the unit is still lying as such, it has not been transferred to somebody else. Yeah, but that means no order right has been.
What happens, my lord, in what they're doing, and the entire mortgage property they've sold.
No, you are interested for your money.
It's not
whatever balance money is there.
just one line, my lord. So that
Who
sold
sold
the
them?
mortgage properties, and thereafter that's rented to the third party, and they are collecting
They're
the
sold or rented?
rented.
Sold, you said sold.
They sold the unit to me.
Sold the mortgage property to
Okay.
other parties
And
without our permission. Then rented to the premises to the third party pullers. They are collecting the rents, but they are not paying the. And also, this honorable court was pleased to direct them to pay the delay period rents within such and such period.
How much? What is the amount?
I'm saying, and in case they fail, then we have said the liberty to pass any order, and we have passed the imperial order.
No, what is the amount, outstanding amount according to you?
Now 5 crores above. Every 5 crores.
କଣ ଆପଣ ସବୁ କ୍ଲିୟର କରିଦେଲେ?
Abu clear. I just accuse they admit. Well, can you annexure one part?
Yeah, post litigation for 5
No, no, no.
ଗୋଟେରେ
What they
39
say,
କୋଟି ଆଉ ଗୋଟେରେ 18 କୋଟି.
the term loan nahi hai clear. Annexure one they admit.
outstanding, still outstanding.
Yes, sir.
No, no, no. That is
10 କୋଟି 18 କୋଟି.
misleading.
ଲକ୍ଷ୍ୟ ଭିତରେ ଥିଲେ ଗୋଟେ ହେଇଥାନ୍ତା ଆପଣ ତ ଲକ୍ଷ୍ୟ ଟପିକ
ନା 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 ଆପଣ annexure one ଦେଖୁନାହାନ୍ତି ସାର୍ ଟିକେ ଗୋଟେ ସେକେଣ୍ଡ.
No, we are referring it to the on their ground that it can be sorted out. But,
I don't have objection.
Amount which he has now raising.
No, no, recall amount that is illegal. I say
that is to be adjudicated by the. So that is why we said that if it is such an amount which can be negotiated there, then it's all right. But this type of thing, otherwise it is to.
ମୁଁ ଦେ ସେମାନଙ୍କ ଦି ଲୋକ 60 ଏତେ difference.
They did not prefer to approach this honorable court for modification of this order or
in time payment करछि ना काहे
did not pay, my lord.
I paid the amount in time within time limit fixed by this court.
Our suggestion is, without going into the technicality, if you can settle the dispute, because see, the people, those who are interested to pay, you don't allow them to pay.
No, no, no.
And once they pay, you
they are not paying. They are collecting the rents.
That is the reason the your institution is.
No, my lord. They are collecting the rent, but they are not paying.
What they do is not more important. Important is how much they owe and how much they pay.
Let it be referred to.
That's the important. They may do whatever.
The Land and Council for both the parties submit that in view of the nature of dispute, the matter may be referred to for mediation. So the cyclist will be mediation. They will report time in the in the meantime. They will
try if anything happens.
Yes, next. Yes. And this is to be listed with that the second. Yes, next.
Item 16.
Milord, on behalf of Senior Advocate J.K. kindly adjourn this matter to next.
Mr. Patnaik, what do you say?
My lord, this is a personal difficulty. This is a bereavement of the family. My learned senior had called up.
Mr. Mention is made on behalf of Mr. Rothal and Senior Advocate appearing for the appellant for adjournment. Mr. Patnaik and Council appearing for the respondents number 2 to 4 has no objection to such prayer for adjournment. Kebe rakhiba kon ko? January 2nd week. Yes, next.
Item 17.
The 17th, my lord, says kindly adjourn.
Mr. Rothal is here. Okay. Yes, Mr. Maharana. Mr. Rothal has some difficulty with so
as you lordship please. It is a
hearing. Na council na change kar debe. Mr. Maharana is for the appellant and Rothal is for the opposite party. Ana Senior Advocate. So adjourn it to yes.
Fixing to
January second week so.
Item 18.
Yes, Mr. Mishra. Mr. Rao.
In this matter, your lordship remembers the consideration money was refunded only
interest part is
in their
He has given
application.
that demand draft of rupees 30 lakh
Yes, yes.
50,000.
Yes. Then
Now,
he has filed a petition because your lordship's direction was to pay with interest.
Interest, right?
So he has filed a petition saying that they are not able to
not
calculate the
to reduce that interest, not that to waive out that interest. I think
that's
for reduction of the interest.
reduction of interest.
We put a question to Mr. Das that if similar thing happens with how much interest you are claiming.
Right. Your lordship wanted the documentary materials to be produced. So in the IA, which they
What
have.
is the rate of interest you charge, general?
Interest, in fact,
पूरा कमेगी तो दिखाइए 30% 3%
ଏକ୍ସେସ୍ ମିଶ୍ର କରିବ ନା ଆପଣ ପୁଣି ସାର୍ ଚେଞ୍ଜ ହେଇଯାଉଛି ତ ତାଙ୍କର ସେକ୍ରେଟାରୀ ସାର୍ ସେ ଆର୍ଥର
ସେଇ ନା ସେଇ କେସ୍ ଟା ନା
ସେଇଟା କି ଆଚ୍ଛା ସିଏ ସାର୍ ସେ କଣ ହେଇଛି ନା ସେ ଆର୍ଥର ଆସିକି ଗୁଡେ ଦେଇଥିଲେ ମେମୋ ଫେମୋ ବୋଲି ସାର୍ ମୁଁ ପୁଣି ରେଡି ହେଇକି ସାର୍ ଡକ୍ୟୁମେଣ୍ଟ
ଆପଣ କେତେ ପରସେଣ୍ଟ ଆପଣ ଚାର୍ଜ କରନ୍ତି ଡିଫଲ୍ଟ ହେଲେ
30% ଦେବେ ତାଙ୍କୁ ଆଉ
ସାର୍ ମୁଁ ସାର୍ ଦେଖନ୍ତୁ ସାର୍ ମୋ ଆଇଏଟା ସାର୍ ହେଇଛି ସେ କର୍ପୋରେସନ ଆଉ ନାହିଁ ଦରମା କିଏ ପାଉନାହାନ୍ତି ମୋ ଫିସ୍ କଥା ଛାଡ଼ନ୍ତୁ ଆଉ ତାପରେ ଏଇ ସିଚୁଏସନରେ ଏଇ ଅବସ୍ଥା ସାର୍ ହେଇଛି ଆଉ ତାପରେ ସାର୍ ଏଥିରେ ସେ ଯୋଉଟା ବନ୍ଦନା ପ୍ୟାଲେସ କେସ୍ ରେ ସେ କହୁଛି ଯେ ସିନ୍ସ ଇଜ ଇନ୍ ପୋଜିସନ is in occupying that land and also it still is continuing in that land.
That doesn't apply.
Applicable hone?
No, we are not going to that. Your prayer is in IA is to reduce the interest from 18%.
Sir, ସେଇଟା ଯେ
ତ ସେଇଥିପାଇଁ ଆମେ କହୁଛୁ ଯେ ଆପଣ ଯେତିକି ଚାର୍ଜ କରୁଛନ୍ତି ଅନ୍ୟମାନଠୁ ସେତିକି କମ ସେ କମ ଦିଅନ୍ତୁ ତାଙ୍କୁ
ତାପରେ
ଆଚ୍ଛା we are sending it to
mediation of you work it
only
out.
for this
sir khali
no legally we'll see later on work it out
ନାଇଁ ସାର୍ ସେ ତାଙ୍କ ନିଜ ପ୍ରେୟାର ବି ସାର୍ ରିଟରେ କହିଛନ୍ତି ଯେ ଆମେ ବ୍ୟାଙ୍କ ଇଣ୍ଟରେଷ୍ଟ ଦବୁ 6% ବୋଲି ନବାକୁ ଚାହୁଁଛୁ ବୋଲି ସେତିକି
he may agree also mediation
sir out of court
he already in distress because suffering from cancer and all principal amount he has got it
sir
and now he may agree for 6%.
sir may say one thing sir sir ଆପଣ ଯେତେବେଳେ ସାର୍ ଅର୍ଡର ଦେଲେ ଯେ 18% ଆଉ ଏଇ ଯେ immediately that matter was referred to me for my opinion ମୁଁ ସାର୍ opinion କିଛି ଦେଲିନି sir this out of court ତାପରେ ସାର୍ high power committee consisting of additional chief secretary and also principal secretary ମତେ ଟେଲିଫୋନ କଲେ ଯେ what to do sir I told that my father in fact expired on account of this lung cancer immediately disconnected the telephone and directed CGM manager to pay the amount immediately. So in respect of that aspect,
no, they have got the amount.
So this situation
because of our intervention,
because of my friends benevolent acts, your lordship.
No, because whatever the coordinate bench has dealt everything. He said that is the matter is pending the civil suit and no direction can issue. Lordship kindly see the same notice, the auction purchaser, he himself perused that sale notice and took the assets and at various notices said that the bidder in other own interest are advised to get themselves satisfied about the assets to be sold by the inspecting such assets with prior permission of the undersigned of the concerned and verify the relevant land records and will present status and its present status.
Please preserve this argument for the final adjudication where the mediation fails. So we are referring it for mediation.
Sir, out of court, sir, a notice type देखोनी से निजे this civil suit pending तो लिखा है the corporation shall not be liable for any dispute. Sir, हम कोचिस
try to sort it out. If it is
that's what we are saying.
Mr. Rao, just don't insist on that 18%.
That's right.
Reduce and it
that is
go.
26/11/25 order, your lordships have mentioned that Mr.
Sir, last time Mr. damage of कोटी टंगा.
On the next date, land council appearing for OSFC shall obtain documentary evidence as to how much interest the OSFC charging from the loanee.
So that
sir 12% पर अच्छा देइची sir ये जो document है sir अपन sir नियंतु sir.
But the Supreme Court says in these kind of circumstances, 6 to 9% is generally
sir percent sir anu sir seta
So
because
you
of the
just
default.
consider that in the mediation. If anything happens, otherwise.
Report the position.
Sir, ଆମେ actually 12% जोटा sir demand କରୁଛୁ because of the agreement ର ଅଛି ଯଦି default ହବ sir ଏଇ case ରେ ନିଜେ sir sale notice ରେ ସେମାନେ ଦେଖିଲେ ଯଦି dispute ଥିବ ତେବେ ଆମେ claim କରିବୁନି ବୋଲି କିଛି
Persuade him in the mediation.
sir ମୁଁ ତ sir out of court sir 6% sir କରିଦେନ କାମ
You will be agreeing, sir.
ଏଟା sir supreme court ରେ ବି judgment sir ଆପଣ ନିଜେ ବି
Sir, ରାଓ କଣ କହୁଛନ୍ତି?
ସେ sir ସବୁ ରାଜି ହେଇଥିଲେ ସବୁ
6% କରିଦବା?
Let it be sent for mediation, my lord.
ସାର୍ ମଝିରେ ଆଉ ଜଣେ ଆସିକି ଏପଟ ସେପଟ କଲା ପରେ ସାର୍ ମୁଁ ସବୁ ବହିପତ୍ର କାଗଜ ଧରିକି ଆସିଛି ସାର୍ କିଛି ପାଇବେନି ସାର୍ it is a case not to be contested. It is because of the cancer. ସାର୍ ମୁଁ contest କରିବିନି ଭାବୁଥିଲି ସେଇଥିପାଇଁ ସାର୍
କରିବିନି ବୋଲି କହିବା ପାଇଁ
ସବୁ husband ଧରିକି ଆସିଛି ସାର୍ he will not get a single pie.
Right, I will take up this matter next week. Let it come.
Your lordship are referring it to mediation?
Yes, and he has to submit a report.
Yes.
We will file the time limit we are giving.
You also to please be reasonable so that it can be settled.
Sir, ଆଉ ସବୁ ସେ ଜାଗାଟା ତ ଫେରିବା କଥା ସେ ଆଜି ପର୍ଯ୍ୟନ୍ତ
ସିଭିଲ କୋର୍ଟ ଆର୍ଡର ଅଛି ଇଞ୍ଜେକ୍ସନ ଅଛି କଣ
ସାର୍
କରିବେ
ସିଭିଲ କୋର୍ଟରେ ସେଇ ସବୁ ଡିସ୍ପ୍ୟୁଟ ଡ୍ୟାମେଜ ଫ୍ୟାମେଜ ସିଭିଲ କୋର୍ଟରେ ଯିବା କଥା ବି କଥା ହେଇଥିଲା ଆପଣ ସବୁ ରାଜି ହେଇଥିଲେ ପୁଣି ସାର୍ ଆଉ ଜଣଙ୍କୁ ପୁରେଇକି ଏଠି ବଳମାନ୍ୟ କରେଇଲେ
Yes, next item number
କେତେ
19.
କାଗଜ ଆଣିଥିଲି ସାର୍ ସେଥିପାଇଁ ସାର୍ ସବୁ କିଛି ଦେଲାନି କାମ ଆଉ I concede.
Item 19.
My lord, item 19. Senior advocate Mr. Tripathi, BP Tripathi has been engaged in this matter, my lord.
For whom?
And for the petition, my lord.
Where is give the appearance memo or something like that? Is a Mr. Mishra का नाम अच्छी? अच्छा ये राम अच्छा आचार्य नाम अच्छा.
Transfer brief, my lord.
Okay, ठीक है. So what do you want now?
My lord, since he's having some personal difficulty, I'm praying for an adjournment.
So it appears readings are complete, Jita.
Yes, my lord. Reading.
All right, Councillor Nalikija, appearing on behalf of Mr. Tripathi and Senior Advocate, 6 for an adjournment. Is this matter? State Council for Nalikija. Yes. January.
I am for opposite part number 234, my lord.
Please give your name. Have you not filed power in this case? Why your name has not been reflected in the cause list?
I'm for Mr. Sapati, my lord. Mr. Prasant Kumar Sapati, my lord, on behalf of Mr. Prasant.
ये वकालतनामा रे अपन ना कहीं लिखा ही नहीं. Have you filed the वकालतनामा?
Yes, my lord. For opposite part number 234, my lord.
Opposite party number 234. It is Ramdas Achari. It is for whom? This is for the petitioner. How on वकालतनामा कौन सी थी? No, I said I'll file this. Can you say that when you file your wakalatnama, because your name is not appearing here in the cause list, I want to insert your name in the cause list, but we must know that you have filed the wakalatnama, and if so, when you have filed that.
Sorry, man. Clash with the serial number, man.
Not in this case.
No, man. Item number 19.
All right. So rest of the matter, day after tomorrow.
Item number 26, one which I had mentioned, I had taken leave of your lordship to mention it today also.
But you leave in the first hour, so
I was on my legs in another hour.
then
Day after- can it be taken up day after tomorrow, my lords, can it be taken up as the
just
first
make
case
a
after-
mention in the make a mention we are telling you because we cannot release the final disposal matter on the top. So, but once you mention, we can take up if
I'll do it on.
What do you say, Lord Council?
My lord, I have come from Ranchi in item number 31, my lord.
Yeah.
I pray let it be taken up in the second week of January with consent, my lord.
Item number
31, my lord. It is a squarely covered matter by the
just-
Honorable Supreme Court as well as
just a minute.
different high courts, my lord. Item number 31.
31, it is WPC number 28979.
My lord. 5 cases.
Sandhyarani Mahanti.
My lord.
So you are appearing in all these cases.
All these cases, my lord, on behalf of petitioners.
For the petitioner. What is your good name, Land Council?
Mohammed Jalisur Rahman. I will file my attention today.
Yes, my lord.
My lord.
Want
Says the
you are briefing.
Yes, my lord.
Submits
Actually
that,
engaged for that. He was from Ranchi.
the matter may be taken up in January.
Second week of January.
Second week of January. Land Council for the Union of India has no objection to such a prayer made. Accordingly, the matter will be listed on give a date particular date.
In this case, last occasion,
Second week.
last occasion, you should directed to serve the copy of the entire pleadings filed before the London Central Administrative Tribunal by the
That has
Civil
not
Council.
been.
My lord, I have received a copy of the pleadings in 4 cases. 1 cases I have not received. She has not served. And counter I have already filed in all 5 cases. So there is a noting counter not filed in 3rd case, but I have served all the counter copy and also filed.
See that everything is there, otherwise unnecessary it will be
That has
adjusted
to
next time. when we
That,
come.
yes, she has not served the one.
Yes.
I don't want to file
One
any
case-
rejoinder, my lord, because this is a covered case, my lord.
The-
Therefore, I'll argue.
Give the date, specific date, so that the Land Council, as per his give the date. All right.
Take up the date.
Because in the one first case, the Union of India is made as party. But in another 4 cases, he has made party the KVS 1 and 2 or Union of India is not a party. I will serve the copy of counter to the Union of India.
Sort it out.
Second week.
matter to take up this on day after tomorrow. Thank the affidavit one, but I have already served.
Which one?
Item 26 minutes.
26 1, Mr. Mukherjee was mentioned.
Yes.
You file it.
Where is he? He is the
Already served the council.
26 टाकू आणून दुसरा कोण कुठून Mr. Udgata, Land Council appearing for the
It's 4 to 6 minutes.
for the opposite parties number 4 to 6 has filed an affidavit which is taken on record. He submits that he has already served the copy on the Land and Council for the petitioner. Matter will be listed on 20 for the number 10th of December 20.
You serve the copy, otherwise.
Yes.
Okay.
Pardon to make a mention, my lord, one jail appeal matter, appellant in custody for more than 10 years. Connected appeals are mentioned in above. Another matter, my lord, CRLA, appellant in custody for more than 9 years. And IA for bail, my lord. Another CRLA matter, my lord, IA filed for bail.
This is the criminal appeal method. I will file the IA for bail method. This is lady method kind.
The appellant is under jail custody for more than 17 years and another 7 years.
Of the particular matter expired on 5 Shukravar. Interim bail. Give the instruction and yes.
Not a criminal appeal, the appellant is in custody for more than 4.5 years.
Sorry.
Lord, criminal appeal, the appellant has been in custody for more than 4.5 years now.
Please give it to me.
Can I in item 49 sub 3 and item 61, my lords, that I have prayed for bail on health grounds. Can they be taken up before your lordship rises?
Report has come.
In 61 it must have come.
Here.
Weekly daily, second up, item number 1.
Your Lordship, appellant is convicted under section 302 of IPC and undergo for life and 25,000 of fine.
What is your name?
This then.
Huh?
Lordship, Devasis Bari.
You have got power in this case? No power. None. Also, admit for the trial court record interim applications for bail and to relation of fine to be considered after receipt of the trial court record. Deposition copy to be supplied. Yes, next.
Item 2.
30.
तो 773 days दिले जाते थे जो असल जो यही ना जो special drive ये दिले कॉन्डम करी तो तो देखी है दिले कॉन्डम करी एडमिट करी कि काउंसिल तो सीरियसली कर केस कर दे पूरा सब उड़न से
କେତେ ପଡିଥିଲା କେତେ ପଡିଥିଲା
हाँ देखना सब सब कितने वर्ष
Item 5.
हाँ नहीं 3 4 3 को ये तो 302 Yes, this matter was there. You have to intimate us what happened.
Time 27/11 totally estimated to the and talk to the IAC today. You want some time development about the recaptured.
Here is also say was perhaps staying in that Biju Patnaik and is it a case of that after expiry of that follow period you didn't serve? You are reading this matter. So have you received paper book also?
Yes. How similar. Day after tomorrow first question.
What is it? 302. Eyewitnesses are there.
No.
Eyewitness there?
No. In fact, when paper would associate my lord, day after tomorrow first case.
As grateful is this matter on 10th of December 2025. Yes.
All right.
Item 6.
NTP jailers. In this case, my lord, I have filed an I 415 of 2025 seeking for bail as he is in custody since 1/7/2025.
Where is the IE?
File it today.
File today.
What is the IE number?
415 of 2000.
415 of 2025.
My lord. 6.
Aji file kar dando. Mr. Patnaik Land Council appearing for the appellant submits that today he has filed an interim application for bail, which has been registered as IA number 415 of 2025. Copy of the interim application has been served in the Land Council for the state. Here, I think you have produced that custody
conduct and CV.
You have already produced out of this matter on 10th of December 2025. With IA number 415 of 2025. Yes.
Item 7.
Yes, Mr. Sethi.
In this case, Lordship has granted interim bail to the appellant. Lordship is yet to surrender.
Not surrender.
Not yet. His tenure ends on 2/9/2/12. He is yet to surrender.
No. What is your instruction? Whether he has surrendered or
No,
no instruction.
No. And he has not surrendered.
Not surrendered.
Acha.
Not in custody.
Have you got any?
Yes.
Just highlight it.
That is not a signed one. It will be signed. Detail. Regarding the jail conduct, custody certificate as well as the pattern showing that he has not yet surrendered. He was released on bail on 3/9/25.
The non-appeals for the appellant. Land Council for the state has produced the written instruction dated 8/12/2025 from Superintendent Jail Balasur, which shows that after availing the interim bail period, the appellant has not surrendered the jail custody. The instruction is taken on the stop. Let a report be called for from the Learning Trial Court regarding the steps taken to apprehend the accused, the appellant. Order be communicated to the land and trial phase and matter will listed on 18th of December 2025.
Item 8.
Please, this is for interim bill matter. The last time again.
Okay, got this. I don't have the report. Hard copy. Can I take a print out?
But his father is very serious.
Yes, sir.
What is the report?
Because his father is serious. So,
No.
in the meanwhile, he
Confirm.
has already discharged
Huh?
from the
You have to
hospital.
confirm us by because
Yes, sir.
that is the reason why we kept it to today.
Yes, sir.
She got the report,
He
but
has been
hard copy is
discharged
not.
from the hospital. I've got the
Right.
report. Not a
Hard
print.
copy continue.
Discharge since 28/11/25.
Discharge.
Yes.
Then, yes, madam, if he has discharged, then what is the necessity?
Madam, operation was not only ଯେ ପଡ଼ିଗଲେ ତାର ଫାଟି ଯାଇଥିଲେ ସେଟା ଖାଲି ଷ୍ଟିଚ୍ କରି ଛାଡ଼ି ଦିଅନ୍ତି and thereafter they say that କି ଆସିଲା ପରେ ଯଦି ଭୋମିଟିଂ ଇଏ ହେଲା thereafter ସେମାନେ ଅପରେସନ କରିବେ ଇଏ ଯେହେତୁ ପିଟିସନର ପରେ ଆସିବେ ତାଙ୍କ ମୋବାଇଲ ଟା ଚୋରି ହେଇଯାଇଛି ଏସସି ମେଡିକାଲ ଲେଡିଜ ପିଟିସନର ମଦର ୱାଜ ଦ ଓନଲି near the father of the petitioner ମୋବାଇଲ ଟା ବି ଚୋରି ହେଇଗଲା ଲେଖା ହେଇଛି ସେ ଡିସଚାର୍ଜ ସାର୍ଟିଫିକେଟରେ
To attend the
ବୁଧବାର ନ୍ୟୁରୋ ସର୍ଜରୀ
if necessary.
ଅପରେସନ କିନ୍ତୁ ତାଙ୍କର ହେଇନି ମ୍ୟାଡମ ମାଇଲଡ
In case of persistent vomiting, seizure and headache, altered scenarium, double vision report.
Casual OPD after 30 days,
Yes.
if necessary.
This is the standard format or what?
ଏଇ ନଥିଲେ ବୋଲି ତ ଅପରେସନ ଇଜ ନଟ୍ ଡନ୍ ଓନ୍ଲି ମେଡିସିନ ଦେଇକି ଡିସଚାର୍ଜ କରୁଛନ୍ତି ଲେଡିଜ the petitioner's mother is the only.
What is the age of the father?
Age of the father is
50 years less age.
Clear.
As per the report, 50.
The only son. Is he only son?
No, you must kindly see the
elder son of the family.
ଆଧିରେ କୌଣସି ଜାଗାରେ ଲେଖା ହେଇନି ଆପଣଙ୍କର
Operation.
ତାଙ୍କର ଅପରେସନ ଦରକାର ନମ୍ବର 1 ନମ୍ବର 2 ବାପା ଅଲରେଡି ଡିସଚାର୍ଜ ହେଇଗଲେଣି ଆଉ ତାଙ୍କୁ ମେଡିକେସନ ଦିଆହେଇଛି ସେ ଅଛନ୍ତି ତ ଆପଣ ଯୋଉ ଇଣ୍ଟରିମ୍ ବେଲ୍ ଚାହୁଁଛନ୍ତି on a particular ground. So what is the necessity? That's why you said that operation କଥା କୋଉଠି ଲେଖା ହେଇନି.
Check of the OPD in Budhavar after 3.
Formal जो
Necessary. Only the petitioner patient pakhare only the ladies who has the mother of the petitioner. She was present and she कथाबार्ता भी डॉक्टर से तो कर पारि नाहंती. Thereafter केही छोट पिला तो दी जन छोट पिला अछंती से माने केही कथाबार्ता कर
माल लेडीज मन तो ताको आनिकिनी तो डॉक्टर एससीबी रे एडमिशन करेले न्यूरो सर्जरी डिपार्टमेंट रे ट्रीटमेंट हेले हला तापरे तांगर डिस्चार्ज हला 2 दिन रहिला पर डिस्चार्ज हे गला ता औषध नै कि अछंती
15 days मैंने अभी 15 days for interim well मैं देखी कि नहीं
IA number 396 of 25. This is an application for interim bail on the ground that the father of the petitioner was suffering from brain stroke and he was admitted in SCB Medical College Hospital, medicine ward, second floor, bed number 6, due to fracture of frontal bone on the left side of the brain, and he was in critical condition. When the matter was taken up on 3/12/2025, we asked the Land for the state to obtain instruction. Today, the Land Council for the state has produced documents from the Department of Neurosurgery, which shows that the father of the petition was admitted on 26/11/2025 and he was discharged on 28/11/2025. And some medicines were prescribed, and it is mentioned in case of online. And he was to attend the neurosurgery OPD. The discharge certificate produced by the Land Council for the state, along with the bedded ticket taken on record, considering the submission made by the Land Council for the respective party of the government taken in the interim application, document produced by the Land Council for the state, we are inclined to release the petitioner on interim bail for a period of 2 weeks from the date of release. Matter will be listed on such and such and surrender. Yes, next.
May I? This is a FOXO case, kindly say that he should not involve or
the petitioner shall not try to come in contact with the victim or any of her family members, shall not indulge in any criminal activities. Violation of any terms and conditions shall entail cancellation of the interim bail order. Yes, next.
Item 9. Item 10.
Yes, Mr. S.S. Roy.
Lordship, requesting for adjournment the matter after 1 week.
What is your good name? Give it. So appearing on behalf of Mr. S.S. Roy to 6 for an adjournment, January 2nd week, 2026. Next.
Item 11.
May please speak.
Yes,
On behalf of Ms. Anita Sahoo Hon'Ble, in case 302 of IPC matter, the present appellant is suffering for psychosis NS matter. That's why on dated 27/10 of 2025, Lordship, my Lord is to take instruction, fresh report, health and mental condition of the present appellant.
got it, ma'am. Hmm.
So 2006, 2001, he has been going to the jail doctor.
କଣ ହେଲା ଆପଣଙ୍କ ତ ସବୁ ଚିକିତ୍ସା ଚାଲିଛି ଠିକ ଠାକ
His
ଚାଲିଛି
behavior is very good, satisfactory. He is performing his own duty.
behavior good, satisfactory, condition stable, ଆଉ ମେଡିସିନ କଣ କଣ ଖାଉଛନ୍ତି ତାକୁ ଲେଖା ହେଇଛି ତେଣୁ ସେମାନେ ମେଣ୍ଟାଲ ପେସେଣ୍ଟ ମାନଙ୍କୁ ମଧ୍ୟ ଠିକ ଟାଇମଲି ଔଷଧ ଦିଅନ୍ତି ଏବଂ ନିଜେ ଦିଅନ୍ତି ତାକୁ ଏ ସୁବିଧା ଆପଣ ବାହାରେ ପାଇବେ କି ନାହିଁ ସନ୍ଦେହ ହେଲା।
You are getting treatment.
So
You
why
are improving.
I am praying for adjournment after 5
the land council for the state has produced the written instruction regarding the health condition from the superintendent sub jail Chhatrapur, which is taken on record as prayed for by the land council for the appellant is this January 2nd week 2026.
Okay.
Item 12.
May it please your lordship. My lord, in item 12, the appellant is in custody since more than 10 years and 8 months. It is a conviction under section 302. There is punishment of life imprisonment, that is the maximum punishment. In all other offences, lesser punishment is prescribed. Your lordship may kindly see my conviction date 6/4/2015. And since that date, I am in custody. During trial also, my lord, I was in custody from 6/4/2015 up to, my lord, sorry, I was in custody since 9 months. During trial also, I was in custody. But leaving that, from the date of conviction, my lord, the petitioner is in custody. There is no one to look after. The old mother is there, father is dead. Substantial period of sentence is already over. And allegation that the wife is dead, but
It appears that the bail application was considered on 29/1/2021.
My lord.
And there was divergent view. So the matter must have been directed to be placed before the hard judge. So what happened?
Thereafter, it was placed because Honorable, my lord, may consider Honorable Justice S.K. Mishra and the Honorable Justice Savitri Ratha by Lordships.
No, it's all right. What happened there?
Thereafter, it was placed, Your Lordship. Thereafter, it was placed before assigned bench. And on that date, matter was again an adjournment was sought for, but so it was placed before Honorable Chief Justice and again assigned to regular bench because there is difference of opinion between honorable judges.
Difference opinion third judge pagu jiva na
nahi seta again jehetu Honorable Justice S.K. Mishra was there. Now thereafter assigned bench different judges were there. So
Going to just for some time. After doing
again seta another
but sehi application ta
nahi seta mu not press nahi my lord mu seta not press karchi. It has come with a memo, that is my memo I have not pressed miss case number 1033/2017. That is in the noting also.
Now you filed a fresh one.
I have filed IA number 3231/2020. My lord. 25.
Miss case number 1033 of 2017. As it appears that when the matter was taken off before the division bench on 29/1/2021.
They have consented. Just see the order dated 5/12/2023. Just see that order. See, on the consent of Mr. Patnaik, consultant so and so is directed to lease this appeal before the assigned division bench on 5th. Single judge is passed here. It was placed before single judge and on their consent.
There was divergent views relating to the grant of bail, for which an order was passed to place it before the Honorable Chief Justice for passing appropriate order to refer the matter the third judge to resolve the issue. Stop. The London Counsel for the petitioner has filed a withdrawal memo for this miscellaneous application. Accordingly, the case is disposed of as withdrawn. 1033. Next, year number 3231 of 2025. This is an application for bail. You get that custody certificate and CA and jail conduct. Yes, next.
Also, may call it next week, my lord.
We'll see that is next week.
Item 13.
The person is convicted for life for the offence under section 302 in a fine of 15,000 in default for the sixth rigorous sentence. The person is in custody since 1909-2013, more than 12 years in custody.
Upon Barashi? No. CA nahi dekhi doon. Custody certificate. CA और jail conduct है ना? Yes. Usually all come next week. Keep it on 17th है ना?
Okay.
The full bota wait.
Item 14. May I please, Your Lordship, on behalf of Ms. Nanda, my lord, the offences under section 376(2)(1) and section 6 POCSO. Punishment is RI for life and fine of ₹10,000. My lord, the appellant is in custody since 18/11/2012.
What happened? You have to obtain that wakalatnama? Information. See, information. Look on the Land Council for the state has produced the wakalat of the informant. Let me send the verdict to the Secretary of High Court Legal Services Authority for engagement of a counsel for the informant for opposing the application for bail. Stop. The criminal appeal memo in judgment and copies of the interim applications on the Land Council for the informant in the meantime. Matter will be listed next week. Okay. 17 तारीख ଆସିବ।
Item 15.
Yes.
Yes, my lord. Last occasion, lordship called for conduct of the felon.
You are granted interim bail.
Interim earlier.
8 weeks and then 2
Yes.
weeks.
8 weeks, then 10 weeks. Then another 14 days last occasion. That is for law.
8 weeks, 10 weeks, then
14 days by the government for law.
Custody certificate, conduct of the petition during interim bail. It is 7 years, 6 months. Consider 7 years, 6 months, 6 days. And jail conduct is good. And during the interim bail period also, satisfactory.
11 plus 4. Sentence.
11 वर्ष 2 मास होता 11 वर्ष 2 मास होता हाँ राइट लिखून the learning for the state has produced the custody certificate which shows that the petitioner has been detained more than 11 years. He has also produced the report, the conduct certificate of the petitioner from Superintendent District Jail Nayagar, which shows that. अरे এটা bad লেখা है जी
Behavior in jail custody is bad.
He has produced the so and so report from the IIC Odaga police station that nothing adverse was found against him during the interim bail period. His conduct was good, public satisfactory. Bad लिख लेते थे good जो पूरा खोलो जो jail conduct है. Report is taken on record considering the submission made by the land council for the respective party. Period of detention of the petitioner in judicial custody. Since on earlier occasion, the petitioner has surrendered after availing the interim bail period at right time here, and there is no chance of appeal. We are inclined to release the petitioner on bail allowed. Yes, next. Obliged.
Item 16.
May I please?
The appellant is inside the custody since 16 November 2014.
Yes, yes. You are Mr. Samantra?
Yes.
So, you got the deposition copies?
Yes, ma'am.
Yes.
Is it period of custody? Total
16/11/2014, more than 11 years.
Where is that custody certificate?
My lord, earlier occasion, your lordship called for the custody certificate.
Is it having
receipt? Next week.
Okay.
Day after tomorrow, weekly list.
He made a submission that it is more than 11 years. And the Learning Council for the state seeks some time to produce the custody certificate, criminal antecedent, as well as the jail conduct the petitioner. Raised this matter on 17th of December 2025. A copy of the order be handed over to the Land Council for this day, and we will publish one share. Yes. 12/12/2025. Next.
Item 17.
And 17 by kilos. After direction to obtain instruction of appellant number 1.
As for the order dated 28/7/2025, the London Trial Court has submitted its report, which shows that the appellant number 1, Amala Rautai, has not availed the interim bail period. So now you have filed for appellant number 2.
Yes, Lordship. Prabhati Raut.
She's a lady.
Yes, Lordship. Posted more than 11 years, Lordship. IN number 2909/24.
So what is the allegation against both of you? What the 498
302, Lordship. 304.
Born injury?
Yes, Lord. 290.
Declaration Nashi.
Yes, Lordship.
406
is set back.
Time declaration PG.
You are the sister-in-law.
PW 10 Lordship. Recorded by PW 10 Lordship.
ତୁମର ନାମ କଣ, ବିଳାସିନୀ, ତୁମର ଠିକଣା କଣ, so and so. ତୁମର ଏପରି ଅବସ୍ଥା କିଏ ହେଲା? ମୋର ଶାଶୁ ନଣନ୍ଦ। ଏ ନଣନ୍ଦ ହଉଛି
Yes,
ମୋ ଉପରେ କିରୋସିନ ଢାଳିଦେଲେ, ମୋ ସ୍ୱାମୀ ବାହାରକୁ ଯାଇଥିଲା, ତାଙ୍କର ଏପରି ଅବସ୍ଥା ପାଇଁ ଯାଇକି ମୁଁ ଶୁଣି ସେଠିକି ଆସ, ଫେରିଯାଅ ବ୍ୟାକ୍ ତରଫରୁ। Can you take care of your mother? Huh? They are with your mother in the jail, and the mother has been granted bail, but she perhaps is not interested to come out. The mother was granted bail in July 24. Now
he's 75 years then.
And already dead. Inside his jail custody, he died. He died.
Who died?
Died.
Yes, Lordship.
Hey, you can. Oh, nice.
Postmortem report, Lordship, Annex 1.
Report ଦଉଛନ୍ତି ଫାଷ୍ଟ ଟିକେ ଯେ ବେଲ୍ ଆଭେଲ୍ କରିନି କହିବ। କେବେ ଦେଇଥିଲା?
20/9/24।
20/9/24। ଆଚ୍ଛା, ତାମାନେ ଆ ପରେ ରିପୋର୍ଟ ପରେ ମରିଛି ନାଇଁ ତ?
No, এটা 8/8/25
ଓହୋ।
may not be knowing this.
ବୁଝିକି ଲେଖିବ ନା, ମାନେ ତାଙ୍କୁ as for order dated 28/7/2025, এটা লিখিবে IN number 2909/24. When a submission was made by the London Council for the appellants that appellant number 1, Kamala Rautraya, who was directed to be released on interim bail as per order dated 23/7/2024, till 28th October 2024, had not availed the interim bail period and she in judicial custody, we directed the London trial court to submit a report whether the appellant number 1 had availed the interim bail period as per the aforesaid order, and if so, he surrender at right time or not. The Lenin trial court has submitted a report which is dated 8/8/2025. আমি যে অর্ডারটা করতে লিখলে তো 28/7/2025 submitted a report dated 8/8/25 wherein it is indicated that the appellant number 1 had not availed the interim bail period after the pronouncement of the judgment. Stop. Land counsel for the appellants submitted that Kamala Rautrai died on 21/9/2024, and her postmortem was also conducted, and he has annexed the postmortem report copy to the interim application. Since this aspect of the death of appellant number 1 doesn't find place in the report dated 8/8/2025 of the Lenin trial court, we seek for a clarification from the Lenin trial court over this issue as to whether the appellant number 1, Kamala Rautrai, is dead or not, and why that aspect was not brought to the notice of this court while submitting the report dated 8/8/25. While we placed before the clear judicial, but usual order करते तो आप पर लिखूं तो where is that report about the custody? Have you got it?
No,
Judgment is on.
custody lordship during that she was not bail lordship custody 10/5/2014
କେମିତି ଜାଣିବୁ ଆପଣ କହୁଛନ୍ତି 2014 ଅଛି ବୋଲି କିନ୍ତୁ ଏଟା ନେଇ ଆସୁଛନ୍ତି the Lenin council for the took some time to produce the custody certificate of the appellant number 2 है ना Betty Prabhati Rautrai put up this matter, say same date or 17th it will come.
Item 18.
Well, also last topic, also that Obtain the custody certificate.
Jail conduct and
Factor certificate.
jail conduct and a CA.
आगु रिजेक्ट ହେଇଥିଲା କି
Madam?
ଆଗରୁ ବେଲ୍ ରିଜେକ୍ଟ ହେଇଥିଲା
No, my lord. So this is the first bail application. That bail application disposal that due to the bail application filed along with the appeal memo, and magistrate directed to withdraw the same and face the file the fresh bail application.
No order was passed that time.
No, just simply dispose of this IA.
ନା ଠିକ ଅଛି that was ଆଗ ବେଲ୍ ଟା ଡିସ୍ପୋଜ ଅଫ୍ ହେଇଯାଇଛି 26/6/2025 ସେଟା ନଥିଙ୍ଗ ଆଡଭର୍ସ ଆସିଛି ଆଇଆଇସି ଆଉ ଜେଲ୍ କଣ୍ଡକ୍ଟ ସାଟିସ୍ଫାକ୍ଟରି ଅଛି ବାକି କଷ୍ଟଡି ସାର୍ଟିଫିକେଟ କାହିଁ ଅଛି କି 7 ବର୍ଷ 8 ମାସ
That time suppose more than 8 years.
Obviously 4 ମାସ ଗଲାଣି 8 years କଣ allegation ଅଛି ଆପଣଙ୍କ ନାଁରେ
The allegation is that the appellant is accused that he committed the murder.
ଆଇ ୱିଟନେସ୍ ଅଛନ୍ତି
Yes, my lord, but that not that that not seen the occurrence. While the appellant is paid out from the house, he is seen from his backside.
Which witness?
PW1 means.
no he says about PW10 eyewitness
No, my lord, informant. Informant Pawan Machi.
That's the Mukta Devi.
dying declaration ମଧ୍ୟ ଅଛି ତା ଦେହରେ PW10 my father told that the accused killed the deceased and straight away holding it my father means the informant is
father.
Informant is not a witness to the occurrence.
This is already informant is the PW1. Is also eyewitness. The accused in the same night by 12:30 AM.
No, running away coaching. Direct देखेंगे, but the dead body was lying there with blood, and I was seen running away with an axe. So that is different.
PW1.
Now one to put. Actual assault देखेंगे, but seen that the accused was running away
from my house by holding the axe.
Holding the axe and dead body. Post occurrence.
PW10 says that informant is my father. This is my elder father, and the accused Srinath could be a brother. The occurrence took place on 11/11/2017 in the night at 12:30. We were in sleep. The accused killed the deceased by means of axe on the head. We woke up and found the deceased dead body of the deceased. My father told that accused killed the deceased.
But he has not in the cross-examination first line going. I had not seen the assault on the deceased. Being told by my father and
Any declaration?
Others told you. It was in last line, PW10, the chief examination last line. My father is the informant. Accused killed the deceased and fled away. So obviously PW1 is the informant. He himself had not seen the dealing of blows. He had seen running out. So that part he might have told, but not the other part. देखो IA number 2257 of 2025 is application for the Land Council for the petitioner submits that appellant, the petitioner is in judicial custody for more than 8 years, which would be evident from the custody certificate. So, he further submits that that a single witness has seen the appellant or the petitioner assaulting the deceased. But PW1 has seen the appellant running away from the spot with an axe. And PW10 also stated to have heard from PW1 regarding the appellant, regarding the petitioner assaulting the deceased. The Land Council submits that view of the nature of evidence available under their application may be favorably considered. Stop. As for the previous order, the Land State has produced a written instruction from IAC Mathili Police Station to show that there is no criminal antecedent against the petitioner. And the senior superintendent, Subdivision Koraput, has given the certificate that during the period of confinement, no adverse report was collected against the petitioner. The reports are taken on that form. The Land Council for the state placed the evidence of PW1 as well as PW10 and also Dr. Gide?
27.
And also the doctor bracketed PW27 conducted post-mortem examination over the dead body of the deceased and opined that the cause of death was due to blunt trauma of temporal region of the head and severe bleeding. Considering the submission made by Land Council for the respective party, nature of evidence available on the and the medical examination, while not inclining to release the petitioner on bail on merit, but taking into account his period of detention in judicial custody and the fact that there is no criminal antecedent against the petitioner and absence of any chance of early hearing, we are inclined to release him and keeping in usage let the case for 3 months bail granted. Yes, next.
That one IA is pending for stay relation file.
Nahi asin tha.
IA number the earlier
IA number
19.
देखो
80
2090 अच्छी अच्छी रेकॉर्ड रची दे अपन कोन स्टे रिलेशन फाइन ही ये पर्यंत
नो mercy.
9/1/2020 already he Allah next
Item 19.
Appellant 1 is in custody, my lords. When he is in custody, my lords, I have filed surrender certificate as annexure 2 to the IA. IA 2330.
What about earlier rejection, Mr. Panda?
Earlier applications was rejected. That was Millard's on 38/2024. Thereafter, I went to the apex court Millard's. The apex court permitted me to renew my prayer for bail via Annexure 1 to the IA if the appeal was not disposed of within 6 to 8 months.
6 to 8 months, then you can then you move the application.
Yes.
That's common. What is the period of custody now?
Period of custody now is 8 years and odd, my lords. If you, my lords, may look at page 9 of the IA, the date of arrest is 27/9/2017, and this certificate was granted on 8th of August 2025. Then it was 7 years, 10 months, and 11 days.
Custody certificate annandi.
That is on recorded.
Huh?
That is on record.
Kahin?
On 7/8/2025. The last flag.
अच्छा अच्छा हाँ ABC अच्छा 7 ବର୍ଷ 10-11 ଦିନ ଏଇଟା ହଉଛି
As on 7.
8 ତାହେଲେ ଏଇଟା ଇଏ ହେଇଯିବନି 8 ବର୍ଷ ହେଇଯିବ
ଆଜ୍ଞା 8 ବର୍ଷ 8 ବର୍ଷ ନା
ବାକି
and the entire conviction is based on reliance on 114 of the Evidence Act. Presumption.
Any criminal antecedent?
No.
Jail conduct? Near something else. The Land Council for the IA number 233025. This is an application. Agurator order kichi hitla der pass hitla.
Wakalatnama I am filing.
The custody certificate has been produced, which is on record, and it shows that the petitioner has remained in judicial custody for more than 8 years. The Land Council for the state seeks for an adjournment till next week to produce the instruction regarding criminal antecedent, if any, against the appellant. So also his jail conduct. It is this matter. Sabuda Roshi, 17 tarikh re.
I will not be available.
15th of December 2025. Yes, next. Are you filing that wakalat na?
Yes, I filed
that one. Go on so far. The kahan na katiba na rakhiban? Kati de
with.
Acha with. ठीक है. Next.
Item 20.
May I please? Custody since T2 2018, 7 years, 8 months is in custody.
Completely interim bail.
Interim bail was granted and he was surrendered. Surrender certificate has been filed.
And interim bail केवे जाइए 14/7/2024 death of the father.
Yes, sir. Thereafter, he has surrendered in time, and surrender certificate filed on 8/4/25. Lagi. Last total.
कौन कोई तो original वकालत ना बना as for the order dated Eight 9/2025, the Land Council for the state has produced the VNAMA କାହାର ଭିନ୍ନ ଅର୍ଡର victim ର informant ବନ୍ଧୁ ନାୟକ ଲେଖା ହେଇଛି ଓ ଦୀନବନ୍ଧୁ ନାୟକ ଦୀନବନ୍ଧୁ ନାୟକ କିଏ ହେବେ
Other
ମାନେ informant
informant.
Yep. Prathama signed by the informant. Let the same be sent to the Secretary of High Court Legal Services Council to engage the counsel for the informant and the appeal memo, improved judgment and copy of interim application be provided to the Land Council for the informant, which name shall appear in the this matter on September 12,
I have filed for bail, not for interim bail. Interim bail was availed.
Bail for next.
Item 21.
Made yes. Last of the lawsuits called for the custody certificate and conduct certificate during interim period.
ଆସିଛି କି ତିନିଟା ଜିନିଷ ମଗେଇଥିଲୁ custody certificate, conduct during interim bail and jail conduct. ଆସିନି
What it or no?
what is how to do
Custody and prostitution. Not yet been received. Not yet received, my lord.
Not it received.
ଆସିନି
No, my.
Land Council for this no time to produce the custody certificate of the petitioner, so also his conduct while on interim bail and also his conduct while in jail custody. Put of this matter 17 तारीख रे नहीं आसुन
Item 22.
As soon as you say directed to serve copy period on the income notice.
What do you know?
No, my.
नहीं नोटिस और बनाना नहीं
No, my. No.
Not sir.
My instruction is that notice of already. My instruction is that the notice of already.
Sure. এটা নেক্সট উইক রে ରଖୁଛୁ ନେଇ ଆସନ୍ତୁ ଯଦି ସେ ନ ଦେଇ ପାରିବ ଲେଖା ହେଇଛି ଅର୍ଡର very clear if he has no financial capacity to engage a counsel of his own, then wakalatnama be sent, we will engage a counsel from the High Court Legal Aid Panel. Hala, karan Pokso Act achi. Nahi to?
Custody certificate. Mobile.
ବାକି କଷ୍ଟଡି ସାର୍ଟିଫିକେଟ ମଧ୍ୟ ମଗା ହେଇଥିଲା ଜେଲ କଣ୍ଡକ୍ଟ ମଧ୍ୟ ମଗା ହେଇଥିଲା ସେଗୁଡା ବି ଆସିନି କିଛି ଆସିନି ଚିଠି ଯାଇଛି ନା ନାହିଁ
Yes.
State seeks some more time to obtain instruction regarding this notice on the informant, so also to obtain the custody certificate and the jail conduct of the petitioner. Out of this matter, is for 30%. Yes.
Item 23.
Well, this application has been filed for interim bail on the ground that petitioner wife is
Sir, देखिए ना, एक tweet कर दो, तीन टाची था. ସବୁଥିରେ order ସେଇଟା ଲେଖିବା ଦରକାର। Yes, item 23.
Yes, my lord. The petitioner wife is expecting a child and she is 9 months pregnant. She is in the advanced stage of pregnancy.
IA number 2737 of 2025 is an application for bail of appellant number 1, Hemalata Luhari. The Learned Counsel for the petitioner submitted that the appellant number that the petitioner is in judicial custody for more than 11 years. The custody certificate available or also indicates the same. It is further argued that since there is no chance of early hearing of the criminal appeal, since it is an appeal of the year 2022, and the petitioner is a lady, therefore the bail application may be favorably considered. Stop. Learned Counsel for the state, on the other hand, opposed the prayer for bail and submitted that key eyewitnesses
PW 9 and 10.
9 and 10.
PW 9 and PW 10 are the child witnesses who are the witnesses to the occurrence. Dr. G.
PW 15.
And PW 15 is the doctor who conducted post-mortem examination over the dead body of the deceased. And he opined that the asphyxial death of the deceased was homicidal in nature and not suicidal. Stop. Considering the submission made by the Learned Counsel for the respective parties, nature of evidence available on record, while not inclining to the petitioner on bail on merit, but taking into account or period of detention, judicial custody, and absence of any chance of early hearing, is inclined to release her on interim bail for a period of 3 months. Date fix up कर देवे तापर ये number 2 टारे custody certificate of renewal. नहीं दे अच्छी दो ना थी 12 वर्ष तक 2 मास होने की देखा दो आई नंबर 500 तार होची चलन नंबर 2 होची 2993 of 2025 submits that appellant number is an application for bail of appellant number 2 Kasinath Luhari. Learned Counsel for the petitioner submit that the petitioner is in judicial custody for more than 12 years. The Learned Counsel for the state has also produced the custody certificate to that effect. The report has also been received from the jail superintendent that conduct and behavior of the petitioner towards the co-inmates and staff is normal, and there is no adverse report against him. The report produced by the Learned Counsel for the state taken on record. तापर से जो eyewitness कथा अच्छा भी सेटा नहीं जिवे ताकि within a mass दे दे है ना
Obliged.
Item 28.
This case for interim.
Yes, item 28.
This case for interim bail for appellant number 3 members on the ground of health condition of his mother.
report and list. Ground of ailment of the mother of the appellant number 4 दिखाई दी
3 members.
3 yes.
3
Zakir Jabir Box.
नहीं सफरुद्दीन सरफू and सरफुद्दीन
तो सेटा रिजेक्ट हे जाइछ appellant number 4 ଓ ତାପରେ ଆଉ ଗୋଟେ ଫାଇଲ କରିଛନ୍ତି 27/10/25 ଗୋଟେ ରିଜେକ୍ଟ ହେଇଛି ଏଇଟା ହଉଛି ସଫରୁ ଆଲିଆସ କଣ
सरफुद्दीन
ସରଫୁଦ୍ଦିନ IN number 518
308 3080
अच्छा 3080 of 25.
सेल नंबर कितने सीआरएल एक बाईस दाम
Mother ailment ground has been taken and she was admitted in the hospital several times and she is now in deathbed. So that instruction, the copy has been solved. So you have not given any medical documents. No. Simple averment has been taken. Wait, what is your instruction?
Instruction notice.
Take that. Look, IN number 3080 of 2025. This is an application for interim bail. Ground has been taken that the mother of the petitioner is suffering from related disease and she was admitted in the hospital several times and now she is in deathbed. Land counsel for the state who has received the copy of the interim application seeks some time to obtain instruction on this interim application, put up this matter on 17/12/2025. Yes, next.
Item 29.
May I please mind?
interim bill
Surrender also, mind.
Yun.
Time, surrender.
कौन अच्छी conduct कौन अच्छी
surrender
ଆସିନି
He was in custody, mind, 9 years.
नहीं नहीं से सब ठीक अछि से conduct ଆସିବ ଦରକାର IA number लिखନ୍ତୁ 942 of 2023 Bharati Das Land Council appearing for the appellant has produced the surrender certificate of the around sole appellant of the appellant which is taken on record. The Learning Council for the state has received the copy of the interim application and seeks some time to obtain instruction relating to the conduct of the petitioner while on interim bail as per the order dated 6/3/24. 6/3/24. Place this matter on 17/12/2025. Yes.
Item 30.
Right.
Yes.
Right. In this case, on order dated my lord of 7/11/2025, the Honorable Court directed to file better application for bail my lord. I was to withdraw the earlier bail application. Now I filed another bail application my lord. In this case, my lord, the petitioner earlier was interim bail for a period of 4 weeks my lord. A report also from my lord while he was on interim bail, his conduct my lord. His conduct has from my lord.
ନାଇଁ ନାଇଁ ଏଇ ଯୋଉ ବର୍ତ୍ତମାନ ଆପଣଙ୍କର bail application number ହଉଛି 3119 of 25 ଆଗରୁ ଯୋଉ bail ରେ ଯାଇଥିଲେ କେତେ ମାସ ପାଇଁ ଯାଇଥିଲେ
4 ସପ୍ତାହ ପାଇଁ
4 ସପ୍ତାହ ପାଇଁ so you have received the copy of the interim application. Yes. ଆଗରୁ merit ରେ reject ହେଇଛି କି
ସେଇ ଫାଇଲର
ଓ ରିଜେକ୍ଟ ହେଇକି 4 ସପ୍ତାହ ପାଇଁ ଦିଆ
3/9/24
ଆଚ୍ଛା ଟୋଟାଲ ପିରିୟଡ ଆପଣଙ୍କର କେତେ ବର୍ଷ
6 years. Customer certificate also form mailer on order dated 3/9/2025. On that date mailer.
ହେଲା ଯେ ଏବେ ରିଜେକ୍ଟ ହେଇକି ଆପଣଙ୍କୁ ଜମା ମାସେ ଦିଆ ହେଇଥିଲା ଆଉ ସେଇ 6 ବର୍ଷ କି ଆଉ କଣ ଆଉ ଟିକେ ରୁହନ୍ତୁ ଫେବୃଆରୀ କଥା ନେକ୍ସଟ
Item 31.
Yes, Mr. Sahoo.
Let me apply. Last occasion, date of birth, certificate of
Last occasion directed to the state council for birth certificate. Production of birth certificate of child of
because that is not updated. The order dated 27/2025.
Petitioner duly अच्छा there is the attention of this court to the evidence of PW 20. The doctor who examined the victim on police requisition and in the cross-examination stated that the victim was not pregnant at the time of her examination. Our learned counsel for the state submits that the medical report which has been marked by the said doctor indicates that the victim was pregnant, and therefore inadvertently the doctor has stated that the victim girl was not pregnant.
Discuss.
अच्छा
Okay.
island Yes, Mr. Sahu.
Beg pardon, Your Lordship.
It is your matter.
Last-
Item number 33.
33, my lord. Item. Last occasion, Your Lordship directed to take instruction from the state.
The instruction has come, and the instruction is verified the condition of the father and mother of the appellant. Found both are in old age. Father is suffering from disease. Staying in Goa since last 15 years with the elder brother so and so. So they are
Elder brother
no
and his
problems.
brother.
ଦି ଜଣ ଭାଇଙ୍କ ସହିତ ଆପଣଙ୍କର ଦୁଇ
But-
ଭାଇଙ୍କ ସହିତ ଦି ଜଣ ଯାକ ଅଛନ୍ତି, ତେଣୁ ବଡ ଆନନ୍ଦରେ ଅଛନ୍ତି।
May I submit, Your Lordship?
ଦରକାର ନାହିଁ।
Both the brothers are not residing at Goa, Your Lordship. They are residing at different place, Your Lordship. Father and mother are
The father and mother are Goa since last 15 years with his elder brothers Sahul Naik and younger brother Mithun Naik. Yeah, lekha hai that is the report.
What I instruction received from the client, Your Lordship.
Instruction kon asthi apno client kon koi diyo.
The-
IN number so and so, these are application on the ground of element of the father of the so and so.
They never visited Goa, my lord.
The so and so which indicates their application I guess stands rejected. Yes, merit re kichh file karchandi.
Merit already disposed of twice, Your Lordship.
Acha, theek hai. Next question.
Item 34.
Please, Your Lordship. On the last occasion, my lords, on 112, the state was asked to obtain conduct of the appellants 2 and 3 when they were on entry.
But we have not received the report. Our report out kon produce kartile sedino.
That appellant 1.
How very 6 on time. Acha. 2 and 3.
2 and 3.
Kon hela?
Report has not- We are sending the letter, but the report has not been issued.
Not come. Produce that. କୋଉଠି ଆପଣ ଭୁବନେଶ୍ୱରରୁ
Khandagiri.
Khondagiri.
ଆଣନ୍ତୁ state 6 some more time to produce the report as per the order dated 1/12/25. ଆପଣ ରହୁନାହାନ୍ତି 15 15th of December 2025. Yes, next.
Item 35.
Yes, Mr. Lenka. Yeah.
Council to take instruction. Custody certificate as well as conduct of antecedent of
ଆପଣଙ୍କୁ କହିଲା deposit କରିବାକୁ cost.
Yes, we are deposited.
Where is the document? You are supposed to produce the receipt in the Advocates Welfare Fund, Orissa High Court, Cuttack. The Land Council for the state has produced the receipt showing deposit of ₹10,000 in Orissa High Court Welfare Fund. The receipt is taken on their personal under account. So now, what is your report? Yeah. Custody ହେଲା 7 ବର୍ଷ ମାସେ ଆଉ not involved in any criminal case. ଆଗରୁ ରିଜେକ୍ଟ ହେଇଥିଲା?
No, man.
କଣ ଅଫେନ୍ସ କଣ?
302 and 201.
eyewitness ଅଛନ୍ତି?
No eyewitness, Lordship.
ତାପରେ 6 ପୋକ୍ସୋ act ଅଛି?
Lordship, subsequently charge sheet has been submitted, but that has been not.
You have been acquitted or what?
My lord.
Then for what offense you are found guilty?
302-201.
Case based on circumstantial evidence.
My lord. Large in
Large
theory.
in theory,
Large in theory.
9 years, the victim is 9 years.
Rape could not be proved or what? He has been accused of 376 and 6 61 ଟା କଣ ଆଇଛି?
61 ରେ ଦେଖିଲ 49 sub item 3 ରେ ଗୋଟେ ରିପୋର୍ଟ କଲ କର।
ଯୋଉଟା ବାହାର କରି ରଖିଥାନ୍ତୁ ପହର ଦିନ ନେଇଯିବା।
Item 44 also why not?
ପହର ଦିନ ଡେ ଆଫ୍ଟର ଟୁମୋର।